the memos. Please give the memos. I'll go through and pass out. Launch over anyone. Please.
Fresh second repeat.
Yes. Any list mention
item 21.
Item
21.
of the supplementary list?
Yes. In that case, government has to file counter, and the government already filed counter that notices was there, but the copy has not served me. So I call this matter on 24th. In the meantime, today they let them. Last time also that counter already filed served the copy. What did they serve the copy? 1 month in the meantime gone. That also 24 in the meantime today they let them serve the copy.
All right, let's matter on 24th September as per.
Right.
Is any other mention?
In the meantime, let them serve.
Yes, yes. Let a copy of the counter be served upon the counsel for the petitioner. Yes.
Item 29. This case is depends upon another case internship between the parties. Say case ro fate upare e case ta nirbhar kore. Eta after 30 pore aswe.
Let's this matter
29.
On 8th October. Yes, as per.
18. That will go to another bench.
Item 18.
My lord cannot hear this matter.
No. Wait.
Mr. S. Mishra is appearing.
Okay. Let's this matter before any other bench with the permission of Honorable the Chief Justice as I am concerned.
Item 41, one time.
Item 41. Yes, let's this matter next week as per.
Particularly item number 1 to be mentioned.
Okay. Here just I wanted one clarification. You have not mentioned when till which date did he, is he still continuing or?
It is not within my knowledge, my lord.
Yes, what is your?
The government.
Yes, that is what I'm asking. Yes.
In fact, my lord, on the last occasion when the case was order was reserved for on the ground of maintainability matter, we are supposed to file the written note, my lord, but we failed to do so, my lord, I beg apology. My lord, in this case, my lord, I am submitting the written note, enclosing the copy of the order dated 10/7/2024 and 21/8/2024, wherein the opposite part number 3, against whom, my lord, the read of warrant has been raised, my lord, that he is no more available in the particular post.
You give him a copy? Give him a copy and file it?
Just now, my lord.
The matter was reserved for judgment because of certain clarification required regarding the date of because of clarification as to whether the opposite party number 3 is still continuing in 2 posts. The matter was listed today under the heading to be mentioned. Learned Counsel for the petitioner submits that he has no instructions in this regard. Learned State Counsel submits that the opposite party number 3 is no longer occupying such posts and files the required orders in this regard, along with a written note of submissions. Stop. Let a copy of the written note of submissions be served upon Learned Counsel for the petitioner.
I have the copy of the order.
Yes, I'll keep it reserved.
My lord, one thing more. I have filed an IA. Praying therein.
After this was reserved for judgment?
No, my lord. It is filed before the judgment is.
So you should have pressed that IA.
I have pressed that your lordship.
No.
Your lordship took a view that whether it is maintainable or not.
Yes, I'm on that maintainability aspect.
After that, I have submitted notes of submission, my lord.
Yes, that is there.
So after maintainability.
Now, do you want to argue any further?
My lord, even if it is apprehended that the person who has usurped the public post, he has left that place. But my lord is well aware about the facts that, and in canon of judgments, it is held by the Honorable Appeals Court. The appointment, if the appointment has been made violating the statutory provisions, it is ab initio void, it is void in ab initio. So if the appointment has been made violating the statutory provisions enshrined under Rule 11 of the Indian Administrative Service Cadre Rules 1954, the appointment ought to be declared as void ab initio. I have filed an IA for that.
All right, but it will all depend on the maintainability aspect, which I am.
Yes, my lord. Yes,
I'm
my
going to pass an order.
Admitted.
I'm going to pass an order. If I hold it maintainable, then I will consider the IA.
Yes, my
If I
lord.
don't hold it maintainable, then the entire thing goes.
May I be permitted?
So, I'll again reserve it for judgment on the on the question of maintainability.
My lord.
Yes, Mr. Patnaik, you wanted to say something?
Yes, my lord. As it has been pointed out, my lord, in the IA, that there is a prayer to declare that particular appointment to be void ab initio. But here, the prayer in the IA is that, my lord, to pass appropriate direction as to restrain the opposite party number 3 from disentitling the important document for his own advantage till the disposal of the writ petition. So, my lord, this prayer, in view of the fact that, my lord, it is a case in the nature of quo my lord, and I have cited 2 decisions, my lord. The extent of the jurisdiction to be exercised by the Honorable High Court while entertaining a quo petition, that only limiting to the point that a person, if in case, my lord, it is found that he is not the appropriate person to hold that particular post, he is to be thrown away from that particular post. He is to be declared as ceased to be the occupant of that particular post from that date only. And with respect to even the act or omission, whatever it has been done, including his entitlement, my lord, that has also been decided by the Honorable Appellate Court, which a copy of the judgment, my lord, I have already cited, my lord. So, in view of this, my lord, this prayer in this IA is also not maintainable, my lord.
Anyway, what I will actually, I have not even, I mean, I have not applied my mind. I was just going through the brief when I found that that particular date was wanting. That is why I brought it under to be mentioned. Anyway, I'm keeping it reserved.
My lord, my learned friend might have not gone through the IA, which is numbered as 10390 of 2024. It is filed on 6/8/2024, wherein it is prayed that it is therefore
That copy is not available with us.
Copy has already been sought.
The only IA is
Copy
available.
has already been sought. On
Anyway, we will see that. We will get into the IA.
my lord.
Only after the if the repetition is held to be maintainable,
Yes,
then obviously it will be listed again for hearing on the
My lord.
non-merits.
My lord.
If it is not held to be maintainable, heard further arguments on the question of maintainability of the writ application. Hearing concluded, judgment is out. Yes.
Item number 2, fresh admission.
May I please, your lordship? I filed this petition for transfer of the CP number 24 of 2024 filed by the wife at Raulkela to Parampur.
Yes.
Petition filed by husband is because, my lord, in paragraph 2, I have narrated that the husband has filed this CP number 165 for 2024. While the wife filed a transfer petition before this honorable court, and this honorable court has sent it to the mediation center. Ma'am. And that is fixed to 20th/9 for mediation. So the prayer is to tag both the case.
But in this case, notice also has to be issued.
Case is before the mediation on 20th.
So we'll take it up after 20th. It is submitted by Sri K. Guru, learned counsel to the petitioner, that another transfer application has been filed by the opposite party wife seeking transfer of
CP number 165.
a proceeding pending in the court of family judge Barampur
Family
to
judge.
the court of family judge Raurkela. Said matter has been sent for mediation, and the date of mediation is fixed to 20th of this month. Hence, list this matter. Hence, place this matter also before the coordinator, Orissa High Court Mediation Center, who shall place it before the same registrar, same mediator, so that a comprehensive resolution of the dispute can be arrived at. List this matter. Sira ke buguro chi date?
8th तारीख.
Huh?
1st October.
List this matter on 1st October. Along with TRP,
TRP 165 of 2024.
TRP 165 of 2024. Yes.
Item number 3. Is the petitioner seeks to transfer the civil suit pending in the court of my lord, civil junior division in Pune to any other court.
Why?
Because what has happened in this suit, my lord, the plaintiff is the president of that bar. Therefore, nobody is interested to appear. Interim application, my lord, with order 39(1) and 2 notice was issued. Whenever at the verge of appearance, nobody interested for appear.
Hmm.
For that reason, the petitioner could not appear. It was
You are the defendant. So 39(1) to Q C seven file kole. हाँ.
appear करे बा करिपलिन को ओकिल राजी पड़लेनी तो हेडे इंटर एक्सपर्टी ऑर्डर हे गला तापर तो सूट टू गला परे से निमा पर ओकिल नहीं केते से एक्सपेंस करियो लोकटा एक्सपेंस क्लियर करि पर बाहर ओकिल नहीं कितो
All right, issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed within 3 working days. List this matter on 5th November. Stay.
Item number 4, interim order.
Stay only, bro.
I am sorry, brother.
In item 4,
Yes, my lord, can have a look to WPC 17048 of 2024.
there, my lord, the counter affidavit, I'm sorry. The counter affidavit in draft form is ready, your lordship may.
Prior to that, my lords, I have filed an IA for amendment and impletion of order. Your lordship, that IA is at page.
Double 1465.
There's an interim order that no appointment shall be made on the basis of such election.
So there is an interim order, no appointment shall be made. They have given appointment and by that they have appointed a person. Naturally, once they have appointed, only say make her a party, then it cannot be.
But how could they appoint?
That, they will explain it. Because your lordship have directed that a free copy to be given to the state. We intimated also to the CDPO. But in spite of the intimation, my lord, they have gone and they have appointed a person.
They may have antedated that order.
Yes, my lord, the
Learned Senior Counsel, Sri J.K. Rothal, Learned Senior Counsel submits that despite the interim order passed on 16/7/2024 by this court, a candidate has already been selected. Stop. It is further submitted that a free copy of this order was handed over, was applied to the learned
state council.
Learned State Council for transmission to the appropriate authorities. Further, the petitioner also informed the CDPO of passing of the interim order. Stop. Learned State Council shall apprise the court of the actual status of the case, and in case the person has actually been appointed, it shall be clarified as to on what basis, as to under what circumstances said person could be appointed despite operation of the interim order of this court. Stop. Learned Senior Counsel further wants to file. You have already filed or?
Sorry, 31st,
I-
28th of August.
IA 114654/2024.
Well, that is in P.
You have any objection to this amendment? You want
No.
to implement? This is an application for amendment of the writ application. Where is the schedule?
When as that is, I have,
Yes.
Yes,
To incorporate certain facts as per the schedule to the plaintiff. Schedule to the petition. Stop. Learned State Counsel on whom a copy of the application has been served has no serious objection. Hence, the application for amendment is allowed. Consolidated writ application.
I have also filed along with that.
Consolidated writ application has already been filed.
Yes,
Let a copy of the consolidated writ application be served upon Learned State Counsel,
yes, ma'am.
who may file counter if necessary. List this matter. What about your matter?
My matter, interim order is there. And
Is the same matter or
Same
same matter, my orders in my matter, my Lord Senior had approached the writ appeal court. So my matter is I am the original petitioner.
No, I didn't understand.
First, I have filed a case where it is observed that my Lord Senior's client did forgery, fraud. And with
Don't use
against
that
that
word.
against that observation, they filed an writ appeal. That is the
That is
dismissed. Dismissed, my lord, writ appeal. Then there was an advertisement. And that advertisement, my lord, against that advertisement, I have also approached this honorable court, and my Lord Senior has also approached this honorable
My
court.
senior's client.
My senior's client, sorry. Obviously, sorry, my lord.
So,
So my Lord and Senior is making who was appointed already make a party, my lord, that may be allowed, and along with that may be hard because he has no.
no, that I have already allowed.
Allowed.
Already allowed. So, but what to do? What order can be passed in your application?
There is no order required. Your lordship has protected me also. No.
So I will just call it on along with this application.
My lord, and my interim order also extended.
Is this matter on? 1st October. ଆଉ interim order କଣ ଇଏ ତ ଏହା ହେଇଛି ଆଉ କଣ?
ତ ଅଛି ସାର୍ ସେଟା ତ
ମାନେ ଯଦି କି appoint ହେଇଗଲେଣି ତାହେଲେ
ସାର୍ ଯୋଉ ଅର୍ଡରଟା ଅଛି ସେଟା ତ ବର୍ତ୍ତମାନ ସେ explain କରିବେ how they could.
no, but if you, according to you, somebody has been appointed, then that order becomes infructuous. So only thing that can be done now is to make it subject to result of the writ application.
How can
How,
it
sir,
All right, interim order to continue.
be? They have done it arbitrarily.
Argument can go true.
Item 1, as is a connected matter, list this matter on 1st October, interim order to continue. Yes.
May I pray for a copy of the order?
A copy of this order be handed over to Learned State Counsel for compliance.
5. Petitioner is a physically handicapped one and belongs to SC category, and also he is a homesteadless landless person matter. Raised for Vasundhara Yojana for 4 dismissal of land in his favor. And kindly have a glance at page number 11 under Annex 3 matter. Tahsildar body issued notice also. Issued notice, Sarvasadaran notice issued on 26/9/2023.
You are Babuli Jana.
Babuli Jana. Till today, my lord, no action has been taken by Tahsildar in my favor, my lord. So my humble prayer before my lordship is 4 dismissal land may be recorded in my favor.
Will directly Tahsildar to take this.
Take.
The petitioner.
Take a final decision.
Yes. The petitioner, obviously. The petitioner claims to be a homestead landless person under the BPL category. On his application, under the Vasundhara Yojana of the government, land measuring across 0.04 decimals was identified for being settled in his favor in Raipur Moja of district of Jajpur district. Plot number as required, a general notice was published by the Vasundhara case number 37-1/2023 on 26/9/2023 by Tahsildar body inviting objections from the general public. Stop. The petitioner's grievance is that despite such notice and expiry of the period mentioned therein, no further action has been taken by the Tahsildar. Stop. Considering the limited grievance of the petitioner, the writ application is disposed of, directing. Tahsildar is not a party.
Opposite party of 3 minutes.
देख ले बीटीजे तहसीलदार से wrongly remove heavily with this approach the
Correct, my lord.
direct the application is most of the Tahsildar body to take a decision in relation to Vasundhara case number 37. In the aforementioned Vasundhara case relating to the petitioner as early as possible, preferably within a period of 4 weeks.
He may be permitted to implead Tahsildar as party.
For 4 weeks from today. Hello? Under intimation to the petitioner. Stop. Prathame lekhantu. Learned counsel for the petitioner is permitted to correct the cause title in court. Havani? Baradara. The paper list. Ago lekhantu. Learned counsel for the petitioner is permitted to correct the
That may be because he is on affidavit, your lordship may permit him to implead Tahsildar. That would be better, perhaps.
is permitted to implead the Tahsildar body as opposite party number 4 in the writ application by making necessary changes in the office. Order can pass. Yes.
No
This order can be passed. He can make it the correction. The correction be carried out in course of the day.
Item number 6.
Petitioner GRS, operating as the accountant from data entry operator after completion of 5 years in one time measure. And a similar order also my lord pass.
Don't. Hello. You know what has happened in this case? What are the facts?
Which disengaged appointing in 2007 and continuing till 2015. And
Yes.
thereafter he is disengaged and reinstated after the interference of this honorable court, and he is appeal before collector and then reinstated in 2022. Thereafter will continue. And
Yes, what do you say?
Your
Same
lordship
order.
may direct as in other case.
Same order कर दो, तो ये correction लगे तो ये correction लगे तो all same order.
second.
Second, I did the connected matter. Same. All it, all.
Item number 7, pattern matter.
In the last occasion, my lord has directed the state government to take instruction whether the inquiry has been conducted in presence of the petitioner or not.
You said that shall produce the file of the joint inquiry conducted to inquire into the allegations received against the petitioner to show whether the petitioner was heard or not. You have the file?
I have the file.
Yes. What does it reveal?
Yes, if passed over, let me.
All right, pass over.
Item number 8. May I please allow? The petitioner, while working as lecturer in political science.
Mr. Das will take up after these partnered matters. Mr. Bera, after these partnered matters, how many partnered matters? Chata. After these 4 matters, we'll take it up again. Yes, Mr. Vishal, what is this?
The petitioner, while working as a lecturer in political science, was illegally restrained from attending the
Road to kono answer to bada order to pass is. What is? Yes. Yes, yes.
The officer directed to produce the case record. The director gave an affidavit that they don't have the record with them. Subsequently, they have produced the record, your lordship.
Oh, yes, yes, yes. So what is the matter? Why did we require that file?
Because director has pursued on the context that I was never appointed in the college.
You were never appointed. That is the.
That is the case of the governing body for the director. The director accepted the same.
Very worried. You will change it.
You will kindly see the impugned order under Action 19.
Annexure 19. To the rejoinder, probably. Annexure 19.
And as Annexure 3, page number 19.
Yes.
It is the order passed by the director higher education.
No, to issue necessary directions of
The last paragraph.
When the initial document required for such the service is a forced one, it will be just and proper to reject the claim of the applicant and the appeal is hereby rejected. So holding that your whatever the fundamental document is fraud or fraudulent or forged.
My lord.
So your claim was rejected. Yes.
Under Annexure 1, I have given that document. at page number 12.
Yes.
So as per the director, I was appointed on 15/1997, but the resolution which was passed by the governing body was subsequent to the appointment order. So the director holds that my appointment was a false and fabricated one. But in the counter affidavit filed by the governing body,
Governing body is opposite party number?
the governing body is OP number, your lordship, OP number 4.
Yes.
They have filed a preliminary counter affidavit. In that affidavit, they have accepted that I was appointed.
Where is it?
My lords, that's at page number. Internal page 3, paragraph 4. That in reply to paragraph 4 of the writ application, it is humbly submitted that the petitioner was appointed as lecturer in political science in the college on dated 15/1997 and joined in the said post of 15/1997. Though the petitioner appointed on dated 15/1997, but the appointment order annexed and annexed over to the petition is a false and manufactured one. The petitioner has not annexed the original appointment order and joining report. The appointment order is 15/1997 as annexed to the petitioner claiming to have been appointed a lecturer in political science as per resolution dated 1997 is a manufactured document on the ground that the so-called appointment order was issued prior to passing of the so-called resolution. But they have enclosed my original appointment order.
So they accept that you were the
governing body has accepted that before this honorable court that I was appointed. But the director has proceeded to the fact that I was never appointed. That is the only ground on which I have preferred this writ application.
So why did you go to the director? What was the cause of action?
My illegal termination replacement, your lordship.
All right. Was anybody appointed in the termination vacancy?
My lords.
Who
I made a party to them.
Who's appearing for him? Anybody appearing? Or the governing body?
LK Mohanty is appearing for the private opposition.
LK
Mohanty. I am for the governing body. I will clarify all these things.
Yes, all right. So he's not appearing, doesn't?
Let my friends
On that limited aspect and before this honorable court. Your lordship, kindly see page number 20.
Hey, page number 20 call आपण सबले annex to refer करतो.
Again,
Because this page number sometimes doesn't match. Because of this scanning thing, which I'm thinking of going back to the old ways. Now, I'm being forced to go back, particularly when I'm hearing civil matters. My God, when you are looking at the LCR.
But being inspired from my lordship, we are now converting ourselves to a digital office now.
Please don't be inspired by wrong things. No, it's all right. See, there's no, I'm fairly computer savvy, but the problem is, if the thing is not, the person who is scanning it, if he doesn't understand what to place in the metadata, you'll open the scanned copy of the LCR, you'll find time petitions, you'll find haziras, you'll find wakalatnamas, but you will not find the exhibits, which are vitally required for adjudication of a second appeal. And when you're hearing a second appeal, you don't want your attention to be diverted anywhere. That is the problem.
The second appeal which your lordship was hearing last week, Mr. Rautra was conducting, I have got that LCR from the scanned copy of the
yes,
LCR.
the pen drive, yes.
Yes. But in that LCR, the exhibits are missing.
Yes, that is very, very problematic. We are taking a call on that. Something will come out. Yes. So what is this?
Annexure 3, your lordship.
Yes.
The next page, page 20.
Page 20.
My lords. During the course of hearing, the GB representative through its secretary submitted that the original GB resolution book, attendance register, acquaintance roll, and dispatch register to ascertain the validity of appointment of the appellant and his continuance in the college. The advocate appearing for the GB submitted written note of submission on so-and-so directed. Next slide is important, your lordship. Heard the matter, perused the relevant documents produced by the secretary GB and written note of submission filed with the advocate appearing for the GB. The stand of defense of the GB in this instant appeal petition is that the appointment order dated 15/1997 as enclosed by the appellant claiming to have been appointed as lecturer in political science as per resolution dated 2/8/1997 is a false and fabricated documents on the ground that the so-called appointment order was issued prior to passing of the so-called resolution. It has been also stated that there is a resolution of the GB in the appointing the appellant as lecturer, and so also no appointment order has been issued for which the question of allegation regarding obstruction prevention to the appellant does not arise. Rather, the case of the appellant is a false and concrete story. Basing on this, your lordship, that I was never appointed, the matter has proceeded. As far as my case is concerned, it was never heard.
Let me just pause for a moment.
My lords.
Mr. Pratap,
My lord.
this paragraph,
Yes, ma'am.
your representative before the
Governing.
before the director.
I was not the conducting.
No, whoever, whatever. It is on record.
Yes, ma'am.
No, this totally contradicts your paragraph 4 of the counter. It is a positive case that he was appointed.
For that reason, you also called for the file of the director.
Yes.
For that reason.
Why?
For that reason, your lordship.
I fail to understand why, man, what was the reason? Please remind me.
My lord.
You have yourself said, forgetting everything.
Yes, my lord.
Admission, this amounts to admission. Let us come to your counter.
In the counter where the governing filed before the director, it was categorically mentioned that, my lord, in that counter filed before the director, that the person suppressing some facts could able to got an appointment from the college. As because when he was got appointed, he was elected member of the Panchayat Samiti.
That's it. We will get into that. We will get into that. But sir, you yourself say, if it is a question of whether he was appointed or not appointed, then you yourself admit that he was appointed.
Yes, that is admitted.
Then how could you say, take a stand before the director that he was never appointed?
No, we have not.
Yes, let us see. And page 20. Let us see page 20. Just what Mr. Bishwal just now read. See, कौन कहले? Is that the appointment order? That is so-called appointment order. It has also been said that there is no resolution of the GB in appointing the appellant, and so also no appointment order has been issued.
No, the appointment order which was issued in his favor and what he annexed before the lordship at Annex 1 is a forced.
Yeah, let us accept it. It is forced completely. But what about your stand? You say that no appointment order was issued, and you have yourself enclosed an amendment of appointment order under Annex A by 4 series.
Yes, that was originally he was appointed. That is admitted fact.
No, but you say something different.
He was appointed.
Yes. So what will come out from the file?
Yes, the file was there. The file in the reply before by the governing body for the director Miller that he was appointed, but when he was appointed, he suppressed some facts that he was elected representative of some panchayat.
Whether he could have been appointed or not is something what you notice. But you said that he was not.
But he did not come to college. Accordingly, so much notice was issued, and accordingly,
that's a different matter. We will see. We will see. But that aspect has not been gone into by the director.
Yes. So that is.
देखे मतलब से बार करी कि सही portion टा flag करी देले the reply counter by the governing body before the director. What stand they have taken? Let me see. 2012 matter. Now again it has to be remanded. There's nothing else. Nothing can be done here because this factual aspect that you are subsequently raising has never been considered by the director.
Yes.
The fact that he was gainfully employed elsewhere and he could not have been appointed. This is your case.
Yes.
But आपण କହିଲେ कोन को डायरेक्टर पाखरे
ଆମେ ସେ କଥା डायरेक्टर କହିଛୁ के से गवर्निंग बोर्ड काम
आगे କହିଲେ कोन होबा अनेक्स पेज 20 टा पढନ୍ତୁ ଟିକେ से पता
डायरेक्टर ऑर्डर
नहीं डायरेक्टर ऑर्डर से कोन लिखिले आपण बोलना हर द मैटर पर written note of submission filed by the advocate appearing for the UGB so आपण काउंटर और written note of the governing body दियो it happens you are not the counsel obviously but से कोन नहीं थे प्लीज देखि दो ना ये रकम काउंटर था
नहीं it is written note of submission.
counter let us see the counter first
Invest person
counter देना
written note दे
written counter behind.
Yes, they have taken also a plea. Yes, Mr. Patnaik.
Yes.
From the RTI document obtained from applicant was working continuing as a Panchayat Samiti member of Mahalinga GP of the said block.
That document is there.
No, document see it.
Para 530.
While the applicant was never appointed nor continued the college as lecturer.
Yes.
Now here before this court they say that he was appointed.
But if your lordship will come to the impugned order as page number 20.
Yes, that is what I'm saying.
Hardly matter.
See it,
Yes,
ko baramar mu kouchi. I'm
Yes.
harping on that. So,
Sethere
this has obviously emanated from paragraph 5.
Okay.
Paragraph 5 and paragraph 1.
One deal करना है only 5.
One रे से कथा कहले ना resolution टा पर हिची केमते अपॉइंटमेंट हेले से कथा तो से कहछिन ना सो 1 and 5 को कंबाइन करके से कर देछिन बाकी पार्ट को जाई नाती
आगे
पैरा 3 रे अपन जो कथाटा कहछिन से बिल्कुल कंसीडर नहीं करे ना किछ नहीं आउथर सुनिबे
आगे
आउथर सुनिबे अब ये फैक्चुअल फाइंडिंग हाई कोर्ट करियो
ना लॉर्डशिप में अरेंजमेंट बट टाइम में
यस मिस्टर पुष्पा देयर इज नो अदर ऑप्शन
As a lordship please.
यस मिस्टर पटेल
Yes.
Very short order रे मतलब सार दूच the petitioner has approached this court with the following prayer para the petitioner claims to the facts of the case are that the petitioner claims to have been appointed as a lecturer in political science lecturer of political science in Ancholiko Bostrani Mahavidyalaya
कलाहंडी
no se jagata na ko
संचारिका
संचारी गांव कलाहंडी
Sanchari गांव कलाहंडी
कलाहंडी
by order dated 15/5/1997 of the Secretary of the governing body of the institution. Stop. It is his further case that while working as such, he was prevented to put his signature in the attendance register in the year 2007, amounting to termination of service. As such, he filed an appeal before the Director of Higher Education on 17/8/2009. Stop. Since the appeal was not disposed of, the petitioner approached this court in WPC number 2371 of 2010, which was disposed of by order dated 15/2/2010, directing the director to dispose of the appeal. Stop. The appeal was thereafter heard by the director and ultimately disposed of by order dated 10/8/2011 in rejecting the claim of the petitioner appellant. Stop. Being aggrieved, the petitioner has approached this court with the following prayer. Stop. A preliminary counter affidavit has been filed by the governing body of the college, bracket opposite party number 4, inter alia, stating that the petitioner was appointed as lecturer in political science in the college on 15/5/1997 and joined in the said post on 16/5/1997. Stop. However, the copy of the appointment order annexed to the writ application is a forged and manufactured one. Stop. The actual appointment order issued on 15/5/1997 has been enclosed as Annexure A/4 series to the counter. It is further stated that the petitioner had suppressed material facts before the governing body at the time of appointment, inasmuch as at that time
Yes.
he was elected and continuing as member of
Panchayat Samit
and continuing as member of the Panchayat Samiti.
of Mahaling Gram. Pardon.
ମୋର ଟିକେ କ୍ୟାପାବିଲିଟି କମ ଆଜ୍ଞା, ମୁଁ କଣ କରିବି, ମତେ ଭାଙ୍ଗିଗଲେ ମୋର ଭାରି ଅସୁବିଧା।
Pardon.
Panchayat Samiti of Mahaling Gram Panchayat under Golamunda block. Stop. Such information was obtained under the RTI Act. Further, the petitioner remained unauthorizedly absent from the college for a long period, and despite request by the governing body, he did not turn up to discharge his duty. Stop. He was therefore served with several show cause notices, which he did not respond to. Stop. As such, the governing body, by resolution dated 7/1/2000, unanimously resolved to terminate the services of the petitioner. Subsequently, this is not required. Subsequently, by an advertisement, one Augusti Sunani was selected and appointed in place of the petitioner on 5/2/2000 and is continuing as such. Stop. The petitioner has filed a rejoinder refuting the stand taken in the counter affidavit, preliminary counter affidavit, by submitting that the petitioner was a state selection board candidate and temporarily appointed as a lecturer by the appointment order dated 15/5/1997, pursuant to which he joined on 16/5/1997. Subsequently, the valid governing body, by resolution number 5/1 dated 2/8/1997, approved the appointment of the petitioner. It is further stated that two other persons, namely Ranjan Kumar Panda and Keshav Lal Sahu, were also appointed on 15/5/1997 as lecturers in Odia and history respectively. Stop. Their appointments were also approved by the governing body by resolution numbers 5/2 and 5/3 dated 2/8/1997. Stop. It is further stated that the petitioner was
The NOC was granted.
the petitioner was elected and continuing as member of the Gram Panchayat Samiti of Mahaling Gram Panchayat at the relevant time, but a no objection certificate was issued in his favor, permitting him to serve as lecturer of political science despite being a member of the Panchayat Samiti. The petitioner further denies the receipt of the show cause notices claimed to have been served upon him by the governing body. That's all. Anything else?
Also to the commission order, he was continuing and he was participating in the selection in the resolution of the management.
That will be decided by the. I'm reminding the matter. I just wanted to place the relevant facts so that they will be on record. So when the director considers it. Heard Sri J. Biswal. And what is your full name?
Jagdish Biswal.
Heard Sri Jagdish Biswal and counsel for the petitioner. Sri S.N. Patnaik. You have not filed your counter.
No.
Sri S.N. Patnaik, learned AGA for the state, and Sri S.S. Pratap, learned counsel appearing for the governing body of the college, bracketed opposite party number 4. Sri Biswal would submit that the stand taken by the governing body before the director during hearing of the appeal directly contradicts its own stand taken before this court, as reflected in paragraph 4 of the preliminary counter affidavit, as also. So stop. In any case, even assuming that the order of appointment enclosed by the governing body is the only valid appointment order, the same proves that the petitioner was appointed on 15/5/1997. Stop. Therefore, only because the resolution of the governing body was passed subsequently, it cannot be held that there was no appointment, as has been wrongly held by the director. Learned State Counsel, what is your stand?
Nothing beyond that stand what it has been taken by the Director of Higher Education, saying that Annexure 1 is a forced one.
Learned State Sri Patnaik, Learned State Counsel would submit that the appointment order, copy of the appointment order enclosed as Annexure 1 to the writ application, a copy of which was produced before the director was found to be a forged document. And therefore, the director rightly rejected his claim being based on such forged document. Stop. Parak. Sri S.S. Pratap, learned counsel appearing for the governing body, would submit that there may not be any dispute as regards appointment of the petitioner on 15/5/1997, but fact remains that he is guilty of willful suppression of material facts, inasmuch as at that time, inasmuch as admittedly he was elected as a member of the Panchayat Samiti of Mahaling Panchayat Samiti.
Mahaling Gram Panchayat.
Mahaling Gram Panchayat. Stop. Therefore, he could not have been appointed as lecturer in the college, and that too by suppressing such information. That's all. Para. A perusal of the after hearing learned counsel for the parties at length and on perusal of the materials available on record, including the original file of the original appeal file, no, appeal file, original file of the original appeal.
By the director.
Original file relating to the director, relating to the appeal. This court finds that the fact that the petitioner was appointed in the college as lecturer of political science on 15/5/1997 is a foregone conclusion, inasmuch as in the preliminary counter affidavit, preliminary counter affidavit filed by the governing body, said fact is not only admitted, but a copy of the appointment order dated 15/5/1997 and the joining report dated 16/5/1997 have been enclosed. Stop. Therefore, even assuming for the sake of argument that the copy of the appointment order enclosed to the writ application as Annexure 1 is a manufactured one, the same cannot take away, the same cannot nullify the fact that the petitioner was actually appointed. Stop. This fact does not appear to have been considered by the director in the proper perspective, and simply by holding the document to be a forged one, the claim of the petitioner was rejected. Stop. That apart from the notes of submissions filed by the governing body, available in the original file produced by the State Council, it is clear that while questioning the genuineness of the order of appointment dated 15/5/1997 relied upon by the petitioner, a specific stand was also taken that the petitioner was continuing as Panchayat Samiti member of Mahalinga GP at the relevant time, for which he could not have been appointed as a lecturer. So, this fact also has not been considered at all by the director. Stop. From what has been held herein before regarding the appointment of the petitioner, regarding the undisputed factum of appointment of the petitioner, it is more than evident that the order of the director cannot be sustained in the eye of law for not having attempted to resolve the dispute comprehensively. Stop. There is therefore no other alternative than to cut off. This court is conscious of the fact that the matter relates to the year 2011. But then the dispute between the parties being essentially factual in nature, this court sitting in a writ jurisdiction, certiorari writ jurisdiction, cannot enter into the factual controversy. Stop. There is thus no other alternative than to remit the matter to the director to decide the appeal afresh in a comprehensive manner after taking into consideration all the grounds raised by the parties. Stop. The writ application is therefore disposed of. The writ application is therefore allowed. Stop. The impugn order under Annex 3 passed by the director is hereby set aside. Stop. The matter is remitted to the director, secondary education,
No, higher education.
higher education, to decide the appeal. There number four tha ki appeal na?
Anko se file number ta jasa.
To decide the appeal afresh after granting opportunity of hearing to all necessary parties and to make all endeavor to comprehensively decide the dispute for all times to come. Stop. The director shall also make an endeavor to dispose of the appeal as early as possible, preferably within a period of 2 months. 2 months from the date of production of certified copy of this order by the parties.
Much
The original file be returned to the State Council.
No, 9.
Already filed the. Check because of lordship, my lord.
Yes, Mr. Mishra.
I've already filed a dead check for lordship and I do the.
Great check. Yes.
That it means.
Oh, that matter. Yes.
Computer teachers.
Yes.
I think got the dead check one.
Yes. You wanted to amend your writ application?
That I have amended and consolidated writ application has been filed.
All right.
That during pendency of the writ application, this honorable court passed an interim order directing them to adjust us. That was rejected. That order was amended, in amendment application that was.
You have challenged it. Yes.
And consolidated with application has been already filed. But in 2000,
That date chart last time you had placed it?
placed it.
Yes.
Subsequently, kindly turn to serial number 5. Agreement. First, I will show you lordship the agreement at page 35. Annex 4, page 35.
Yes.
This is an agreement between the Director of Secondary Education as well as the class, which is a outsourcing agency. But you can look at, my lord.
Yeah, if I remember correctly, the agreement was cancelled because you had issued an advertisement. The organization had issued an advertisement.
For that purpose, I am drawing your attention. Page 35, paragraph 2.
Yes.
The class shall take all necessary steps, including the selection of students.
Sir, you are reading from which?
Page 35.
नहीं annexer कौन?
এটা better দেখাও।
नहीं annexer টা कौन देखा जाऊँ जी?
Page annexer 4.
Annexer 4. So please don't refer to the page number because it is not matching with my. Sashikanta.
Page 35.
Yeah.
Better the copy is also there. Serial number 2.
Yes.
The class shall take all necessary steps, including the selection of students to impact free computer education, which shall be elective subject to need to DD and but meritorious students of rural high schools of the state. Have you got it, madam?
Yes.
So agreement was made that the class will do selection. Then you'll also.
But why does it say that for selection of the students to impart free computer education?
The class shall take all necessary steps, including the selection of students. Students means those who will teach melody. Students is used here.
Why did they use this word student?
I felt on shell also. Then you'll also kind of 9, page 36.
Yes.
The class shall provide self-financing training to the selected computer teacher on teaching computer education in local language of each selected school.
See, including the selection of students or including the selection of the teachers.
Teachers. Then you'll also kindly turn to all communication made by the director, page 41, my lord.
No, sir, 41, but the page कौन तो नहीं?
Annexure 8.
Yes.
With a letter from the director, my lord, second education, I am directed to invite a reference to your letter number such and such on the above mentioned subject and to request you to furnish the list of selected computer teachers along with selection procedure to appoint in high schools for imparting free computer education to this director for taking further action. That is in 2009. Then, my lord, the inspector of schools, right, my lord, that I am directed to say that the chief executive class, Orissa Council for Computer Literacy and Awareness in secondary school has proposed to appoint qualified computer teachers for imparting free computer education in the following high school under your control. You are therefore requested to intimate to the director whether the computer along with necessary infrastructures are available in above schools for imparting this regarding infrastructure and other things. Then you also kindly turn to Annexure 17, page 52. Selection was made, 1 year training was given by the class, then page 50, Annexure 17.
Annexure 17.
Latest status of the empaneled e-teachers for appointment. Let's say, look at the other side. All are written by the director. Director, secondary education, letter number such and such. Director, secondary education, and schools were also allowed. Colleges, school to the particular petitioners. In 2012, they cancelled the agreement. And we have been deprived, despite the fact that we have taken 1 year course training on the class and that O level, which is better than PGDCA. That and the director, as per the director, the posting order was.
Where was it? Rejection order.
Rejection during pendency. That Annexure 19 is perhaps.
As per interim order, my lord.
As per the order, let's see, kindly turn to page Annexure 18.
Yes.
The Honorable High Court of Orissa, while disposing with the miscase number such and such and arising such and such, filed by Sashikanta Mishra and others, pass the following orders. In that view of the matter, if the authorities are going to approve engagement of candidates sponsored by NGO such and such, all are outsourcing projects, such as the case of the petitioner should be taken into consideration and their case should also be taken on priority basis as they have been selected prior to the candidates approved by NGO and other outsourcing projects as well as TCIL. Therefore, steps should be taken by the authorities to consider the case of the petitioner as expeditiously as possible, preferably within a period of 2 months from the date of receipt a copy of this order. Then rejection order. Then, my lord, next page.
Paragraph 2, the petitioner in the grievance petition have stated that they have completed necessary training under class Odisha and have claimed to be qualified to be ICT coordinators to impart computer education in rural schools in the state. Their names were sponsored by class Odisha to various high schools. But without considering their case, the authorities are going to approve engagement of the candidates sponsored by NGO like IL and other outsourcing. That Biju Patnaik Memorial E-Library project jointly organized by the Biju Patnaik Foundation Trust and Council for Computer Literacy and Awareness Secondary School, class Odisha, requested this department during 2002, taking permission for providing for computer education to the native but meritorious students of rural high schools of the state. Accordingly, this department allowed class Odisha to impart free computer education to native but meritorious students for them high school with certain terms and conditions for a period of 2 years. An agreement was also executed between director and class Odisha. At the first page, aforesaid organization was allowed to introduce free computer education in 42 high schools of 42 blocks. In the second place, in the second page, the said organization was allowed to introduce the scheme in 82 high schools. Extension has also been granted in favor of the said organization until further orders with the same terms and conditions. So extension was granted. Then my lord, paragraph 8. Paragraph 4. That it came to the notice of the government in School and Mass Education Department that the said organization has violated the terms and conditions by publishing an advertisement in the Delhi Odia newspaper on 2/11/2012, inviting application from the candidate for the post of ICT coordinator in Odisha school for implementing information communication technology schools program. The scheme was introduced by Government of India in all states of the country to promote computer education in all secondary and higher secondary classes, to introduce computer-related elective subjects in higher secondary class. There are various modalities to be followed by the state government. To implement the program, class Odisha has not been authorized to publish advertisement in connection with the implementation of ICT scheme and engagement of employees under the said scheme, misleading the public. Therefore, this department in public interest has.
Where is that advertisement? Last time you showed? मतलब लाउची आपने देखेला वाले? Because Mr. Mishra, as things stand, the crux of the dispute is whether any illegality was committed by publishing the advertisement. That is the
My
solution.
humble submission it is in consonance with Article 40 of the Constitution. Because even Uma Devi, what he says, that all the eligible candidates should be allowed to participate, and thereby a selection can be made. Therefore, publicly by page Annex 12
12, 13 দিটা আছে
12 and 13.
তো 12 টা পড়া যাবে না দেশের প্রত্যেক সরকারি মাধ্যমিক বিদ্যালয়
ଦେଶର ପ୍ରତ୍ୟେକ ସରକାରୀ ମାଧ୍ୟମିକ ବିଦ୍ୟାଳୟ ଛାତ୍ରଛାତ୍ରୀ ମାନଙ୍କୁ କମ୍ପ୍ୟୁଟର ଏବଂ ସୂଚନା ଦିସ୍ ଇଜ 2009
10 ହଁ ପବ୍ଲିକ
10/2009 ଦେଶର ପ୍ରତ୍ୟେକ ସରକାରୀ ମାଧ୍ୟମିକ ବିଦ୍ୟାଳୟ ଛାତ୍ରଛାତ୍ରୀ ମାନଙ୍କୁ କମ୍ପ୍ୟୁଟର ଏବଂ ସୂଚନା ପ୍ରଯୁକ୍ତି ବିଜ୍ଞାନ ଶିକ୍ଷା ପ୍ରଦାନ ନିମନ୍ତେ କେନ୍ଦ୍ର ମାନବ ସମ୍ବଳ ବିକାଶ ମନ୍ତ୍ରଣାଳୟ ବିଦ୍ୟାଳୟ ଶିକ୍ଷା ସରକାରୀ ବିଭାଗ ନିକଟ ଭବିଷ୍ୟତରେ ଏକ ଜାତୀୟ ନୀତି ପ୍ରଣୟନ କରୁଛନ୍ତି। ପ୍ରସ୍ତାବିତ ନୀତିର ସବିଶେଷ ବିବରଣୀ କେନ୍ଦ୍ର ସରକାର ମାନବ ସମ୍ବଳ ବିଭାଗ ୱେବସାଇଟରେ ଦିଆଯାଇଛି। ତେବେ 2000 ମସିହା ଠାରୁ ଓଡ଼ିଶା ସରକାର ରାଜ୍ୟ ସମସ୍ତ ଛାତ୍ରଛାତ୍ରୀ ମାନଙ୍କୁ ଉପଯୁକ୍ତ ସେଲ୍ଫ ଫାଇନାନ୍ସିଂ ଦେୟଯୁକ୍ତ କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ଉପଲବ୍ଧି କରାଇବା ନିମନ୍ତେ ରାଜ୍ୟରେ ଇ ସ୍କୁଲ ପ୍ରୋଜେକ୍ଟ ପ୍ରକଳ୍ପ ଆରମ୍ଭ କରିଥିଲେ। ପରେ କେବଳ ଗ୍ରାମାଞ୍ଚଳ ହାଇସ୍କୁଲ ସମୂହ ଛାତ୍ରଛାତ୍ରୀ ମାନଙ୍କୁ ଫ୍ରି କମ୍ପ୍ୟୁଟର ଶିକ୍ଷା ପ୍ରଦାନ ପାଇଁ ରାଜ୍ୟ ସରକାର ବିଦ୍ୟାଳୟ ଓ ଗଣଶିକ୍ଷା ବିଭାଗ 2003 ମସିହାରେ ଏକ ସୁଚିନ୍ତିତ ବିଜୁ ପଟ୍ଟନାୟକ ମେମୋରିଆଲ ଲାଇବ୍ରେରୀ ପ୍ରୋଜେକ୍ଟକୁ ଅନୁମୋଦନ କରିବା ପରେ ଉକ୍ତ ପ୍ରକଳ୍ପ କାର୍ଯ୍ୟ କରିବା ନିମନ୍ତେ ବିଭାଗ ପତ୍ର ନମ୍ବର 47 ଏବଂ ପତ୍ର ନମ୍ବର 47 ଅନୁଯାୟୀ ମାଧ୍ୟମିକ ସାକ୍ଷରିତ କ୍ଲାସ ଓଡ଼ିଶା ସହ ଚୁକ୍ତିନାମା ସ୍ୱାକ୍ଷର କରିଛନ୍ତି। 2003-04 ଶିକ୍ଷାବର୍ଷରୁ ରାଜ୍ୟ ସରକାର ମାଧ୍ୟମିକ କମ୍ପ୍ୟୁଟର ସ୍ୱାକ୍ଷରିତ ପରିଷଦ ମିଳିତ ଉଦ୍ୟମରେ
all right, I get the point. Now, Mr. Patnaik, I will ask you to pause for a moment. How does this offend the agreement? He has referred to the agreement also.
Well, your lordship was referring to that annex 19 in my brief. Annex 18 in their brief, but That is para number 4, internal page number, para number 4, my lord.
The rejection order, sir?
This, that rejection order.
Yes.
There it says, my lord, that one advertisement was issued in the Delhi Orient newspaper on 2/11/2012.
That is also there probably, Annexure 30?
No, that is of 2010, 9,
Yes.
10, and thereafter, my lord, Annexure 16 is of 2011. That has not been taken into consideration for the cancellation of the
Anyway,
termination of agreement.
2/11/2012 has been taken?
Take that 2/11/2012 is their the rejection order. But advertisement says is 9/4/2010 and as well as.
No, sir. This is published and by publishing an advertisement in the Delhi Odia newspaper on 2/11/2012.
Yes, ma'am.
2/11/2012 is nothing, is not in the petition, neither counter nor petition. On the contrary, materials available on record at Annexure 13, page 12 and page 13, that is in relation to on 9/10/2009 and 9/4/2010.
No, then,
And that is their rejection.
no, then
Clearly,
I will ask you, Mr. Patnaik, you have to find out this advertisement.
Yes, because we have.
That is one part. That is one part. Notwithstanding the copy of the advertisement before us, we can straight away ask you that question.
Yes.
How do you think that violates the agreement?
My lord, that is what I will submit.
Yes.
But one part is that, my lord, the petitions before your lordship are not the representative of the class. It is the agreement which was terminated. It was between the government and class. And my lord, once that agreement stands terminated, my lord, thereafter, my lord, the new person, they actually replaced class. Now, what we had decided that after the new organization, that is boot system, my lord, we have clarified that one in the same rejection order, that the petitions have every right to apply through those organizations, my lord, because they are purely private organizations, and we are actually getting the work through some contract of a particular organization, through a particular organization, my lord. And these are the persons who are to be employed, even, my lord, by class. They are not the employees under the government. They are the employees, claimed to be the employees of the class. Now, class is no more with us. And the class is not before a lordship or any other proceeding also, my lord.
That on the last occasion also I had pointed out to Mr. Mishra.
Yes.
Because this order has been passed against class.
Yes. The termination of agreement is
we
actually
have to call with the class because class given to the director issued the letter and posting letter that I have shown your lordship. So we have nothing to call or in conflict with class. My submission for lordship is very limited. That in the year 2003, there was a clear agreement. It was extended till 2012. And I have shown your lordship a clear 2 advertisement in 2010 and a page annexure 3 and 4. I'm sorry, page 30, page 2, annexure 12 and 13.
Yes, that I've seen.
That you lordship sees, that is one is 9/10/2009, 9/4/2010. Now the rejection order says Odia newspaper on 2/11/2012, which is there is no materials on record to say so.
Last time also, I think I had crystallized the point, Mr. Patnaik.
Yes, ma'am.
The point that you're raising is basically a technical plea.
Yes.
Class, even if you remove class from the equation, fact remains that class had made an advertisement and had selected, even forgetting the advertisement, he had selected some persons,
Yes.
given them training, and they were allotted schools. So they are affected by this order. So while simply by, cancelling the advertisement, what you are trying to do is you are trying to pull the rug under the feet of the persons.
But if the subsequent paras will be read, my lord,
Yes.
that particular rejection order, there it has been clarified. And so also, my lord, annexure A/4, my lord, A/2, that is 10/12/2012. The letter of the government, man.
That
These two
agreement was
letters, my
cancelled.
lord, that we have stated categorically that these persons, they were never the employees of the government.
That's all right. That's all
Just
right.
like, my lord, outsourcing.
And they,
Again, today you are giving 5,800 some odd I filed interim
Yes.
application.
But that is
Two again outstanding, NGO.
yes, that is what, my lord, the policy is.
you say that the petitioners may offer their candidature in response to the advertisement issued by them for their selection on merit. It's all right. The question is, they have already come through a selection process. They are already on the board.
Basis, my lord. They cannot exercise their right, my lord. They cannot claim that they have the right to continue.
True.
All that, my lord-
Appointment was
Yes,
there.
ma'am. Yes, my lord.
But that is never a state appointment under the state.
Yes.
You cannot say.
Because there was an agreement between the state. But last 5 years, 6 years back, all appointments were contractual.
No, it was a schematic.
Policy decision was taken to regularize.
No,
in
this is
2013.
you cannot claim that any benefit under that act.
No, once there is an agreement and we had undergone training for 1 year, naturally we are the beneficiaries, even if because it is perennial in nature. Computer teacher is not schematic or it will close.
No, so that will be decided. That question will be decided. That's a policy matter that has to be decided by the government. Whether looking at the perennial nature of the job, whether the people will be regularized or not.
Solution is once you made an agreement and it continued from 2003 to 2012. Meanwhile, we are selected through advertisement. We appeared before a class and selected. Director communicated to all inspector schools regarding our posting. Thereafter, will say that I don't have a right, my lord, I have nothing to submit.
No, Mr. Patnaik. Yes. Now they were selected by class.
Yes.
By whatever method, and they were allotted certain schools.
Yes, ma'am.
Was it for certain period?
No.
Let us look at the order of the director.
Once, my lord, the order of engagement, the contract is for certain period, my lord. Their engagement must be valid for certain period. But
let us see the order of the director.
Yes.
Annex 70.
They have an M-panel as e-teachers.
Yes. And it's 17.
Look at.
If they are already M-paneled, and if you enter into agreement with some other organization to run this scheme, why should they go under the process again?
No, madam.
They are already M-paneled.
If a lordship come to the impugn order once again, my lord.
Yes.
This stands what we have taken. Now, my lord, up to para number 4, my lord, it has been placed with lordship.
Yes.
Para number 5, my lord. That ICT, a direct school scheme, is implemented in the state through build, own, operate, and transfer. That is boot model. The work of the engagement of the school coordinator is entrusted with the boot operator, but not this department. The Odisha Madhyamika Shiksha Mission executed an agreement with Odisha Knowledge Corporation Limited, OKCL, and OKCL entrusted the bidders, that is IL and FSETS Limited and TCIL, through open tender for implementation of the scheme. This said limited is entrusted with the work for implementation in 27 districts. In TCIL is entrusted with 3 districts. They have already made advertisement for engagement of the school coordinators in the daily newspapers and have selected the eligible candidates as school coordinators for implementation of the scheme purely on contractual basis. Then, lordship, the important para is para number 7. The school coordinators have been engaged through outsourcing. The implementing agencies, IL, FSETS, and TCIL, are purely private organizations. The petitioners may offer their candidature in response to the advertisement issued by them.
This is what I don't understand. This particular part you have to throw light more, because under the earlier arrangement,
yes, ma'am,
an agreement was signed with a particular organization.
Yes.
And some persons were selected and impaneled.
Yes, ma'am.
Now, every time you go on changing the agency,
that's
so will that process be again repeated? I don't think so. That could not have been the
outsourcing basis, my lord. It has to be.
No, I'm granting you time, please.
Yes, ma'am. I will clarify that.
Yes. No, you clarify.
And I will produce that particular advertisement day also, my lord.
Cancel the agreement with me and immediately gone for other outsourcing people for selection.
Heard for the
Again,
arguments.
they may cancel their agreement.
We have
now
not
they have
supposing there's a violation of the agreement by a new agency.
Yes.
So the entire thing goes again. There will be another agreement with a new agency. And again, he will appoint.
Yes, my lord, because the outsourcing, the persons who were engaged to outsourcing agency, they are never the employees of the organization.
No, absolutely. They are neither employees of the organization nor of the state government. They are impaneled for being entrusted with a particular work.
Yes, ma'am.
Now, if the agency goes on changing, will these people change? And will it endure to the benefit of the students? That is what I would like you to answer. We have to look at the larger picture.
To the students, my lord.
Now we'll have to look at the larger picture.
Yes.
Isn't it?
But the thing is that, my lord, so far my limited knowledge, my lord, with respect to the outsourcing agency, it is the persons who are getting engaged through outsourcing agency and those persons who are actually getting the direct payment. from the authorities, my lord. There is a difference between.
There's a difference. I 100% concede to your argument.
And they are.
But the thing is that
employees of that outsourcing agency.
So what happens is, since it affects their employment also, it affects their livelihood, they cannot be treated simply technically. Their claim for being absorbed as government employees, that's another matter. You may say that. You may object to it.
Yes.
You may object to it. Validly, you may object to it for whatever it is worth. But whatever there, some remuneration they are being given, and it's a matter of livelihood. Anyway,
I can understand the system is closed. I can understand it is, you are making a contract with X. You do not like him or other purposes. Then you have given to Y. And now your para 7 is saying, again, we have to appear and before them.
it is like,
Under another organization.
no, it is like
Outsourcing.
you are, when these agencies are concerned, these agencies have to implement the scheme
Yes, ma'am.
with the empaneled persons.
Yes, ma'am.
This appears to be, at least from the face of it, it appears to be like that. Let us see. Let us go deep into it. Anyway, heard further arguments in part. Learned State Counsel. In course of argument, attention of this court is drawn to paragraph 7 of the impugned order, bracket annexure 18, wherein it is stated that the petitioners may offer their candidature in response to the advertisement issued by the implementing agencies for their selection on merit. Stop. This court would like to know whether the petitioners who are already empaneled and empaneled for serving as e-school teachers, e-teachers in different schools also need to be thrown out for in favor of persons to be selected again. Does this matter? This is just a question of argument. You have to obtain instructions and argue, and we'll close it on the next day. Is this matter on 1st October? Yes.
My lord, in this case, I appear in OP5, my lord.
Yes. Who is OP5?
My lord, appearance.
Class.
Board of Secondary Education, my lord.
Yes.
Board
Subsequent agreement was made, therefore you.
Yes.
Not 10.
My lord, item 10, Lordship, as a last chance, Lordship, I pray, Lordship, keep it after lunch. I will file the affidavit, Lordship. Further affidavit I am filing. I am enclosing the.
Car mobile version. Yes. Yes.
Lordship, I will be filing further affidavit. I am enclosing the resident certificate which has been given by the Sarpanch of the village that I am a resident of that locality, Lordship. So, Lordship, as a last chance, after lunch, I am praying for after lunch.
Counsel, the petitioner undertakes to file further affidavit in course of the day. After serving copy on the other side.
Right.
Does this matter? 17th September. Password collected.
So, item number 7.
In item 7, your lordship wanted to see the joint inquiry report, but I don't get it in the record. May I pray your lordship may? As I was going through the records, I don't find. If your lordship permits, I can submit with your lordship. But
Already-
the CDPO has written that the villagers did not want her.
Yeah, that's a different matter, but
Yes.
what was the joint inquiry? I don't know what.
Joint inquiry.
So you examine the file again. I'm granting you time till next week. You examine it and make your submissions.
I will send for that.
Learned State Counsel has produced the file of the joint inquiry and requests for some time to go through the voluminous documents contained therein. Let's this matter next week.
Item number 11.
Matter has been compromised, my lord. IA number 834 of
Oh,
2024.
this is RSA. Okay.
Filed by the both the parties. The parties are present, my lord.
You filed a compromise petition, joint petition. Upendra Rai. Devaki Rai, Upendra Rai, Devaki Rai, ডাকুন। IF 834 of 2024. The appellant Upendra Rai and the respondent Devaki Rai are present, being identified by Sri B. Sahu, learned counsel for the appellant, and Sri
Abhas Gadnaik.
Sri Abhas Godnaik. Yes, Abhas Godnaik, learned counsel for the respondent respectively. अरे अब respondent को लिखा अब ठीक है देखो तो चेंज करें. Further, they produce their original Aadhaar cards, which are returned to them by after on being substituted by the attested photocopies thereof. Stop. ଆପଣଙ୍କ ନାଁ ଉପେନ୍ଦ୍ର ରାୟ, ଆପଣଙ୍କ ନାଁ ଦେବକୀ ରାୟ, ଆଜ୍ଞା ଆପଣଙ୍କ ନାଁ ଦେବକୀ ରାୟ, ଆଚ୍ଛା ଆପଣ ଏଠି ଗୋଟେ ଦରଖାସ୍ତ ଦେଇଛନ୍ତି କୋର୍ଟରେ ଯେ ଆପଣଙ୍କ ଭିତରେ ଆଜ୍ଞା ଆପଣଙ୍କ ଭିତରେ ଗୋଟେ ମିଳାମିଶା ହେଇଯାଇଛି। ଆପଣଙ୍କର ମିଳାମିଶା ହେଇଯାଇଛି ଏଇ ଆଫିଡେଭିଟରେ ଆପଣ ଦସ୍ତଖତ କରି ଟିପ ଦେଇଛନ୍ତି ଦେଖେଇଲ ତାଙ୍କୁ ଦେଖା ଦେଖା ଦେଖ ତାଙ୍କୁ ଦସ୍ତଖତ ଦେଖାଅ ତାଙ୍କୁ ଦସ୍ତଖତ ଦେଖାଅ ତାଙ୍କୁ ସେ ଉପେନ୍ଦ୍ର ରାୟଙ୍କୁ ତାଙ୍କୁ ଦସ୍ତଖତ ଦେଖା On being asked, both parties admit to have put their signatures / LTI on the joint affidavit, on the joint application. This is an application for compromise filed by them as per terms mentioned in paragraph 5 and 6. 5 and 6 though? Paragraph 5, 6 and 7. 5, 6 and 7. No, 5, 6, 7 and 8 of the application. Stop. The parties further submit that they have entered into this compromise without any pressure or coercion from any quarter whatsoever, and that they have decided to amicably resolve the dispute in the manner stated in the application. ଆପଣଙ୍କୁ କେହି ବାଧ୍ୟ କରୁନାହାନ୍ତି ସାଇନ୍ କରିବା ପାଇଁ ଉପେନ୍ଦ୍ର ରାୟ ଶାନ୍ତିରେ କରିଛନ୍ତି ଆପଣଙ୍କୁ କେହି ବାଧ୍ୟ କରିନାହାନ୍ତି ଆଜ୍ଞା ଆପଣଙ୍କୁ ପଛରେ ଦିଅନ୍ତୁ ଠିକ ଅଛି having regard to the submissions as above, the joint application for compromise is accepted. The RSA is disposed of in terms of the compromise, comma with the compromise application forming part of the decree. Stop. The decree be drawn up accordingly.
Item number 12.
We have filed an IA for amendment.
Yes. Now you are filing.
Yeah, already filed and short copy.
What amendment?
Amendment in the
Where?
prayer portion and the plaint, also in the plaint.
Yes. Who's for the Union of India? Who's appearing?
Mr. CORAM was there, but in another copy.
For the Union of India, nobody.
There's an application for amendment of the writ application as per the schedule mentioned therein. Since the amendment appears to be formal in nature, the same is allowed. Consolidated writ application be filed within a week after serving copy on the other side. Place this matter on 24th September.
Item 13. Of 13th tomorrow. ଆପଣ କାହାକୁ appeal କରୁଛନ୍ତି? ମୋର ସେଟା ଯୋଉ appealant.
You are on a different list probably. You are in a different list.
I'm sorry, I'm sorry.
In 13, your lordship had directed for service on the principal through the sub-collector. It has been reported that it was served on him by the sub-collector himself.
Item 13.
Yes, ma'am.
Sir,
Basant Kumar Pradhan.
it was served on him.
Sir, there is another order. Sir, this is item number 13, sir.
Yes,
Sir,
5016 of 2013.
sir,
ତାଦେହରେ ଗୋଟେ ୱିଥ୍ ହେଇକି ମ୍ୟାଟର ଆସିଛି ସେଥିରେ ଅର୍ଡର ପାସ୍ ହେଇଥିଲା କି
Sir, ଯୋଉ WPC 5016 of 13 ରେ
ଅର୍ଡର ଡେଟ୍ ଟା କେତେ
order ଟା pass ହେଇଥିଲା sir.
Order କେତେ?
5016, I'm sorry, 5016 of 13.
ଅର୍ଡର ଡେଟ୍ ଟା କେତେ
Sir, order date ଟା ଥିଲା last. The order date was the 20.
Sir, the last order, let me read out. I think there is some confusion. Sir, kindly, last order.
sir.
The Mr. A.K. Sahu has entered appearance for the opposite party number 3. Order takes to file Vakalatnama in course of the day. He submits that the petitioner has in the meantime expired and his wife has been receiving family pension. Let an affidavit be filed by opposite party number 3 incorporating the death certificate and other documents regarding death of the petitioner and receipt of family pension by his widow as claimed. Learned senior counsel appearing for the petitioner submits that he has no instructions in this regard.
Even sir, said that no instruction to the effect that the petitioner has died.
Obviously.
He has not filed any.
Who's appearing? A.K. Sahu nowhere to be seen. We'll call it tomorrow then again.
Yes, fine.
We'll call it tomorrow. Learned senior counsel Sri J.K. Ratho is present. None appears for the opposite party number 3 on repeated calls. Let's this matter tomorrow.
Item 14.
Paper on Passover.
Passover at 12:15. Call it Passover.
Item 15.
Item 15.
May I please your lordship? Lordship, fact of the case is like
Files and affidavit, copy was Mr. Manthilini.
petitioner was given a retirement from the Uttara University as a junior assistant.
Yes.
He was initially appointed as a consolidated employee in the year 1989. When his services were
No, 83.
83, sorry, my lord, 83.
Yes.
When his services are not regularized, then he approached this honorable court. This honorable court given direction to regularize his services. Thereafter, his services were regularized in the year 2013. Thereafter, by attending the normal age of superannuation 60 years, he was given a retirement in the year 2015. Now, question is, your lordship, after retirement, he is not getting any pension. He has filed this writ petition to count that period as qualifying service for the purpose of pension and pensionary benefit. And in the meantime, your lordship, subsequent development, and I have also attached that document, annexure 5, page 20, your lordship, kindly see. That period has been regularized. That is with your lordship permission I am placing. Pursuant to the order passed by the Honorable High Court of Orissa in WPC number such and such, subsequent order passed in Sri Pratap Kumar Mohan petitioner is hereby regularized as junior assistant with effect from 1/10/1983 in the scale of pay such as per ORSP rule with usual dearness allowance and other allowance as admissible under the rules of the university from time to time. He is allowed to draw his salary, etc. Now that entire period has been regularized. So there is no obstacle. In the meantime, your lordship, university has filed an affidavit, your lordship kindly see that affidavit. That affidavit dated 16/8/2024. Page 4 of that affidavit, your lordship will see annexure D. Did my lordship, that is reply affidavit filed on behalf of the opposite party number 1 and 2. That is the heading.
Khali affidavit ଅଛି
My lord, no, that is heading is the description of the document. That is your lordship will see. That is dated 16/8/2024. That university has filed by the opposite party number 1 and 2 through. Did my lordship get it?
That has been filed before your lordship on 28/2024.
I'm not getting it, sir. I'm getting one affidavit which is at flag N, which was of which you have, I think it was filed on 2/8/2024. That is by
So
Pratap Kumar Mahanti at
that is petitioner. That is reply, but your lordship, my submission that
देख लो
university-
affidavit अच्छी की hard file है देख लो hard file
that copy is with me, your lordship.
it must be, but it may not have been scanned.
Right.
Hard copy तो था ही करे नहीं ठीक है नहीं अपन फाइल कर सकते
Yes, my lords, on my record, I have stated that it was filed in court on 28/2024.
असुविधा क्या था
And your lordships,
That is the affidavit and that is
I served a copy.
annexure G, your lordship, kindly.
no, but what remains now?
That is your, that he is taking the plea that we have written a letter to the government, Secretary Higher Education, and he is to pass a formal order. Otherwise, that will not be released, your pension amount. But I was given a retirement in the year 2015, now 2024. And for this reason, your lordship, I am not getting any pension, low paid employee. And your lordship will see my objection to that affidavit. In case of others, only formal order is to be passed, has been passed, and that is also I have attached that.
I don't think the government has to pass any order. I don't think.
My
My
lord,
lords, my lord may kindly visualize the university being a state university, the authorities cannot go buy a Alpine even without the.
No. The university statutes permits that.
No, but the block grant that they get, that only which is permissible. For
Once
these-
block grant has been sanctioned, has been paid, has been disbursed. So you don't have to go to the government with a begging bowl every time.
No, in
या हमें तो पेंशन दो अपना सैंक्शन कौन वही
because block grant comes once, and within that, out of that, that cannot be given.
and in any case this has been issued in August 2024 when he had retired since 2015. What were you doing for so many years, Mr. Patnaik?
So, there were communication.
So the university will pay not only pension but will also pay interest on pension.
No, on the last occasion, what I had submitted before your lordship is this affidavit was served on the state also. So I had requested my learned friend.
No, you are trying to pass on the buck, Mr. Patnaik. The university is trying to pass on the buck. No, nothing doing. I will issue a mandamus and I will direct the university to pay interest.
In that case, your lordship may kindly visualize that will be from their own sources.
Maybe, doesn't matter.
That will be
Whatever
from
the
their own
sources.
sources.
After a person has served since 1983 till 2015, and now till now you have not finalized this pension matter, which is very unfortunate. Yes, state, what have you got to say on this? What have you done?
We had sought for instructions from government,
What instruction?
as your lordship had directed the other day.
Yes.
The registrar has requested the special secretary government in Department of Higher Education. by-
Let him appear tomorrow with all the instruction, whatever. Let him file an affidavit, what he has done in this matter. Let him appear. Or I'll call it tomorrow, you take instructions. Telling which he'll appear day after tomorrow. No, nothing doing. You can't treat an employee like this. ये affidavit कौन करे ये reply affidavit नहीं affidavit ଅଛି ପରା reply affidavit ନା କେମିତି metadata ସେ entry କରୁନାହାନ୍ତି କେମିତି ଜାଣିବେ କଣ scanning ହଉଛି କହିଲେ କେମିତି ଜାଣିବେ ପ୍ରତ୍ୟେକ ଜିନିଷରେ ଦେଖନ୍ତୁ memo of appearance କଲା ତାପରେ ଏଇ ଦେଖିଲେ କଣ କରିବେ ମାନେ how can one deal with it? In course of hearing, attention of this court is drawn to the document enclosed as Annexure 9, which is a letter dated 9/8/2024, written by the registrar to the Special Secretary to Government in the Higher Education Department, seeking sanction, seeking reconsideration of the matter relating to payment of pension through block grant of the petitioner. Stop. This court observes that the petitioner being a low-paid employee, has retired way back in the year 2015. It is a matter of regret that his pensionary dues have not been finalized as yet. Apparently on the ground of, apparently on technicalities. Learned State Counsel shall take instructions in this regard as to what action has been done, action has been taken on the letter of the registrar referred above. List this matter day after tomorrow. I am granting you one.
May I pray for Monday?
No, sir, ମୁଁ କାଲି କରୁଥିଲି day after tomorrow କହିଲି କାଳେ ଆପଣ ମାନି ପାରିବେନି ବୋଲି ଆଉ Monday ନା. କାଲି ନହେଲେ I will straight away issue a mandamus, you go to division bench, you go to Supreme Court, wherever you want to go.
May I pray one thing?
Next year, G.
In my read petition, I have only annexures 3, 1, 2, 3. For other annexures, I don't have.
G, that is your lordship just now dictated.
Annexure 9.
G of that affidavit.
Annexure 9 will लिखी
No, that is G, but it seems like 9, but it's capital G.
Capital G. You can't blame me for my failing eyesight nowadays.
That occurs with everybody.
But that is 9 ବେଳେ ଦେଖାଗଲା ବୋଲି it's a small G ବୋଧେ କରିଛନ୍ତି ତାକୁ.
No, capital G. Capital G, probably my handwriting is such. So your lordship.
Then I leave it at that.
Mother annexure G ଟା ଦେବେ ମୋ ପାଖରେ ନାହିଁ.
नहीं, तुम दे दी.
Maybe you would copy this, so that how, otherwise how will you obtain instruction?
More F ଯାଏ ଅଛି.
Mr. Das,
Sir.
you understand the mind of the court. I couldn't have made myself more clear.
Sir.
Get it done within 24 hours. It is there. If they want, they can immediately do it. Pass orders or matter ends.
So, your lordship has read that for further reconsideration in the sense, earlier the state had said that we will not be in a position. So this has been
Reconsideration word means obviously. So I did not deliberately get into that. I did not deliberately. After all, poor employee and he's somebody who has worked and you don't dispute his credentials.
No, I do understand your lordship's concern.
No, absolutely. If this court doesn't come up to the person's rescue, where will he go?
Exactly.
Where will he go? Yes.
Item 16.
Item 16, your lordship. This matter recently transferred to me, your lordship. Today I am filing the wakalatnama.
No objection of the previous counsel.
No, yes, your lordship.
Very
16.
Ms. Sucheta Guman Singh enters appearance for the petitioner after obtaining no objection from the previous counsel. By filing wakalatnama, the same be kept on record. The name of Ms. Guman Singh be reflected in the cause list after deleting the names of the previous counsel. Yes, what is this matter?
So, this matter is about giving the appointment to Sikhya Sahayak.
Are you ready today?
No, your lordship. I will take some time.
All right. List this matter on 24th September, as prayed for.
Deeply obliged to lordship.
Item 17.
Disengagement of DRS by the collector without taking any feedback from the panchayat. And the government has already filed a counter and I have filed the rejoinder, my lord. The counter.
Postal tracking report indicates that the notice on opposite party number 5 was delivered on 21/8/2024. There is, however, no appearance. Yes. Anybody appearing? Yes. What is your prayer? You are challenging?
I'm challenging the disengagement of the GRS, my lord. Petitioner is.
So file an appeal? File an appeal before the Director of Special Projects? Appeal provision is there? Yes. As per the comprehensive guidelines, file an appeal?
2018.
Yes. File an appeal. When was your order passed? When was that order of disengagement passed? 2017.
Annexure 5, my lord.
Annexure 5 is 2017. File an appeal. Yes. We'll condone the delay. Yes. When did you file this? 4/5/2017. When was the 12/4/2017? So within 1 month, he has approached this court. We'll condone the entire period. We'll ask him to file appeal. Yes. Sir. Factual aspect, this court will never enter. You have a better chance for the appellate authority.
Have misinterpreted the guidelines. That is why I filed the rejoinder, my lord.
What interpretation? Well, that the appellate authority will do. I can enter into. I know. From 2017, the matter has been kept pending, and now I'm relegating you to another forum, but that is in your own interest. You decide. You take a decision. If you want, that could be a risk. Because this court, in a certiorari matter, will be very, I mean, focused only on any infraction flaw. Other than that,
I'm relying upon the guidelines they have mentioned in the counter Miller. They have challenged it that GRS is not appointed by the Gram Panchayat, but by the preservation procedure by the collector. And the second ground they have stated that Sarpanch is not the appointing authority. And third is that the job chart issued by the Panchayat department, wherein that is mentioned of 54 points, and the petitioner has not complied with their job charts. And fourth is that petitioner has been issued with a letter by the Sarpanch cancelling the agreement. That is a subsequent during pendency of the petition. If the lordship see the guidelines, annexure A by 4.
why will this court? Because this also involves a question relating to your performance, which the BDO has certified. BDO has recommended disciplinary action against him on account of his poor performance. Now, how can this court enter into this?
Only the Panchayat can do it.
Maybe.
Because their guideline shows annexure A by 4. Only the Panchayat is the appointing authority, Panchayat is the removing authority. Only Panchayat can do it.
Where is the impute order of disengagement?
That is annexure 5.
So decision was taken and an opportunity of personal hearing was granted. Yes, what do you say?
Yes, my dear. The counter affidavit has been filed, stating that your lordship will kindly find from paragraph 10. Whatever has happened has been elaborated. He had not
No, he
submitted
says that the collector is not competent to disengage him. But let us come to the comprehensive guidelines.
At page 11, annexure A by 4.
A by 4.
A by 4.
A by 4 is not the.
I read that.
No, there is another.
Engagement of staff of Gram Panchayat.
It has been superseded. That this comprehensive guideline has been superseded. When was it superseded? Please see.
It has been relied upon by the state.
at page 11 of the counter affidavit.
Yes.
The panel is to be approved by the collector. Panel of 3 names. From out of that panel, the Sarpanch is to give appointment.
Only the collector has to prepare, facilitate the process. They have prepared a panel, and out of the panel, the Sarpanch will engage somebody else. Only the role of the collector is to facilitate the process. Because of Panchayat Raj is the institute of self.
Likewise, collector cum CEO Jila Parishad is also competent to take disciplinary action, including removal for unsatisfactory performance, indiscipline, or otherwise after getting feedback from concerned Gram Panchayat through program officer.
No feedback here.
Feedback nahi, but he is competent to take disciplinary action against you.
No, Milord, because it's a Panchayat is the institution of self-government, Milord, on Article 243G of the Constitution, Milord.
Yes, what do you say? If this is the point, we'll take it up then. We'll consider whether the collector was competent to.
In fact,
Even
all letters from
same
government.
stand was taken in the Manaswamy case also.
Manaswamy kon mujhe nahi.
Milord, in the Manaswamy said they forbid the. Kindly turn to page 20.
Yes.
Page 20, the last para 16. The operational guideline 2013 for edition of MGNRJ 2005, which has been filed by the petitioner annexure 7 to the agenda affidavit. Under clause 2 of chapter 18, which deals with strengthening of Panchayat, it has been stated that the staff provided to Panchayat under MGNRJs would work under the superintendence and control of the Panchayat concerned, including disciplinary powers. Therefore, it is contained that the action taken by the opposition 4 in annexure 4 is in gross violation of the operational guidelines And more so the petitioner having appointed under the Gram Panchayat. And the Panchayat has got power of superintendence and control over the action done by the GRS, including disciplinary powers at the behest of the collector. The opposite partner court could not have issued relief order.
Well, do you submit in light of this judgment? Well, heard in part, is this matter on the 1st October.
Interim order.
Interim order to continue.
There is a mistake in the typographical error in the order dated 6/24.
Order dated 6/8/2024 be corrected accordingly.
First title ta bole chhe aur advocate name bi se
Correct.
I don't know, 19.
Yeah, it will go to another bench. I am concerned in that matter. There was a mention made in the morning, so I released it from my bench.
Typographical error of the court.
Sira, court hobo. Why is order ignorant? Yes.
The judgment to copy.
Yes, item 19.
Yes, ma'am. My lord, the appellate order is assailed before your lordship,
Appellate order passed by
passed by the,
Anganwadi matter.
yes, by the ADM. My lord, before taking into the other facts of the case, your lordship may see the appellate order for a minute.
Who's for the private opposite party?
My lord, last occasion on 20th of March 2024, they had, 13th of March 2024, they had taken time to file a counter. Till that, no counter has been filed.
All right.
The state has filed.
State has filed.
State has not served me a copy.
Oh, sorry.
Yes, Mr. Bose.
My lord, may kindly see the appellate order under Annexure 1.
Yes.
My first ground of attack of the appellate order is, my lord, the appellate court just jotted down the facts of the case, and your lordship may kindly turn from page 10.
Yes.
My lord, he notes page 11. Heard the learned advocate CDPO Bhograi Rural and additional gone through the papers, document including written arguments available on record. Learned counsel advocate for the appellant stated as follows. Then the next page your lordship will see, learned advocate for the respondent says this. Learned advocate for the respondent says this. Then the learned government pleader says this. CDPO Bhograi says this. It is observed as follows at page 13. The CDPO Bhograi has cancelled her notification dated such and invited fresh application by notification to fill up the post of Anganwadi worker in respect of Dubo Site 2 Anganwadi Center. The appointing authority has the right to cancel the advertisement and go in for fresh advertisement. Well, under the fresh advertisement, I have applied. I don't dispute this. The follow-up action has already taken as per notification of such and such. Appellant as well as the respondent 2 to 4 participate in selection process by notification dated such and such as applicants. The respondent number 1 completed 18 years as on 2000. From where he got it? When I have produced materials under the RTI Act that she was born on such and such date, the marriage with the person with whom, under whom he's claiming that I'm in the service area, was born and he was underage on the date of alleged marriage. That was not dealt. Then selection engagement of respondent number 1 is right genuine as per government. He does not discuss anything in the appeal. Rather, in my appeal memo, I have given the appeal memo. Your lordship will see at Annexure 7, page 35. I have detailed everything. No discussion. My lord will kindly turn to page 38.
Yes.
Ground number A, B, C, D, and E. Nothing has been discussed. He just jots down the points which has been raised. No discussion. Is it a way, my lord? I put a question to myself. Is it a way to deal with an appeal? You are the last court in appeal. Appeal court will find out the points, whether those points are there or not, and he has to see whether it is applicable to the facts and circumstances.
All right, I get your point, but since the opposite party number 5 is not there, I'll grant one more opportunity and then.
Well, on last occasion he did not.
I'll keep it parted now. Third in part. लिख रहे तो ऊपर none appears को लिखा है Shri A.P. Bose, learned counsel for the petitioner is present. Learned State Counsel Shri A.R. Das is also present. None appears for the opposite party number 5.
2.
Opposite, no, the private opposite party.
2.
None appears for the opposite party number 2 on repeated calls. Heard in part. Place this matter on 1st October.
I do not want the
Pleasure loss. The petitioner for lordship, though her appeal was allowed by the supplemental annex of 5 page 22, but she has on A card 2019 unable to get the engagement Angani worker because of another writ petition pending at the behest of opposite party number 4. For the selection has already been set aside by the sub-collector.
So that appeal has to be heard, that writ application has to be heard before.
That is not challenged. That order of sub-collector in which the
Maybe, but you say that it is because of the pendency of another writ application that you are unable to get the fruit of your decree.
Yes.
So I think, so it depends on, yes. That is the other matter, 17769.
Yes.
Here, in this case, the present petitioner in the first case, who secured the lowest mark, 53 point something, and the petitioner, where I am appearing, she secured 69.5. The crux of the matter is that she submitted the residence certificate after the cutoff date. She applied for it. When she got it, on that date, he had submitted the application. When the matter was scrutinized by the scrutinized committee on 1/9/2016, she had submitted. 27/7/2016, she got the residence certificate. So on 1/9/2016, when the committee seat for the scrutiny and for the final selection, the residence certificate was available. And she has, at the time of application, she has submitted the residence certificate of 2013. And in the survey list, the name of the petitioner was found in the survey list that is there. Only because after the cutoff date she has submitted, that is the ground. But here in this case, also your lordship has decided a Gita Rani Behera case where the survey report has been upheld. And also because after the advertisement, she came to know, then she has applied for the residence certificate. And I raised the question of also the locus standi of the petitioner in first WPC, who has secured lowest mark in 4 candidates. And I am secured 69 marks. But as for this Honorable Court Division Bench judgment, nowhere in the guidelines there is any bar to accept this residence certificate after cutoff date. There is a judgment of this Honorable Court Division Bench judgment. And there also the petitioner secured the highest mark. I would like to place that advertisement, and Supreme Court in a judgment also in similar situation after cutoff date, they have submitted their certificate. I'm reading that part. The appellant was given appointment in the sports quota, even though he did not submit the certificate in time. The fact remains that certificate was accepted, though after the cutoff date. And the appellant has already worked for 7 years. I have worked for more than 8 years. There is no dispute about the genuineness of the certificate. Under these circumstances, we set aside the impugned order and allow these appeals and leave the appointment of the appellant undisturbed. And similarly also, another judgment in Supreme Court, they have not submitted the OBC certificate. So they have, their candidature has been rejected. And Supreme Court, they says that if after cutoff date they have submitted, and before the side that after cutoff date they have submitted, they approach the apex court after para 13 re lekha hai. After hearing both the parties at length and perusing the impugned judgment and order passed by the division bench of the High Court, we are of the view that division bench erred in setting aside the judgment and order passed by the learned single judge. We record our reasons hereunder. The division of the High Court erred in not considering the decision rendered in case of Puspa. In that case, the learned single judge of the High Court had rightly held that petitioner therein were entitled to submit the OBC certificate before the provisional selection list was published to claim the benefit of reservation of OBC category. The learned Singh judge correctly examined the entire situation, not in a pedantic manner, but in backdrop of the object of reservation made by to be reserved categories. So they held that the ST category could not be rejected simply on account of the late submission of caste certificate. And our Honorable High Court, in a division bench in Anganwadi case, Mamata after cut-off date, they have submitted and leave it. Here in first paragraph, that mentioned that inter alia on the ground that respondent number 3 had submitted residency certificate on 28/2007, 2 days after the cut-off date. By order dated so-and-so, learning single judge dismissed the writ application holding inter alia that the respondent 3 has been engaged as Anganwadi worker and in the meantime 8 years have been elapsed. And finally, para 12, concluding para. In course of hearing, we put a specific question to Mr. Mishra, learning counsel for the appellant, as to whether the respondent number 3 is eligible and more meritorious than the appellant. His answer is in affirmative. Mr. Fondal and an additional government advocate submits that the respondent number 3 is not only eligible but also more meritorious than the appellant. In meantime, 8 years have elapsed and she is continuing in the said post. He further submits that the judgment cited by Mr. Mishra are distinguishable in the facts and circumstances of the present case. That Deepak Dipti Mai Parida judgment they have cited. In view of the 8 years and she is more meritorious than the appellant, we are not inclined to interfere with the order passed by the learned single judge. And also, your lordship, in a Gita Rani that I was placing, Gita Rani case, upheld the survey report and raised the question of locus standi, because the petitioner who secured the lowest mark and para 2 re gote jagare likhchanti middle part, wherein the petitioner was found to be more meritorious on the basis of the total points awarded to her, ignoring any deficiency in the late submission of residential certificate.
Yes.
And similarly, para 12. Para 12 ro last 2 lines.
Yes.
On the side that petitioner failed to produce the original required certificate and she produced it at a later date after she received it on 27/7/2016. They have accepted that I have received, after receiving, I have submitted before them. Para 13 ne bhi selection the last 2 line. The said guidelines are not in dispute, so also the conditions stipulated in the advertisement are not in dispute. And para 14 re, it is humbly submitted that there is no bar for the authority to take a decision on basis of verification report and survey, as well as to take note of the fact the contents of the residence certificate, particularly when such residence certificate was never produced within time stipulated in the order. They consider all these aspects. And thereafter, they allowed and consider and given me appointment since 2016. I am working there. And kindly have a glance to their own prayer in the read. First read petition.
166.
May I read, ma'am? Graciously pleased to allow this writ petition issue writ of mandamus directing the opposite parties, most particularly opposite party number 2 and 2, to engage the petitioner. My appointment has not been challenged. In the post of Anganwadi worker, Kunjapalli 2 Anganwadi Center, within a stipulated period by disengaging the respondent opposite party number 5, as per the order of the sub-collector chairman opposite party number 3 under Annexure 6. But Annexure is not, 6 is not the order of the sub-collector. Annexure 5 is the order of the sub-collector. So they have not challenged my appointment.
All right.
The writ petition cannot be allowed.
All right, we'll continue this matter on some other date. Date karo. Heard arguments in part. Leave this matter on next week. Rochi. Next week. Mr. Manti. Yes, Mr. Manti. Next week. next week, next Tuesday. Today is 10th, it will come on 17th. Okay. Take it back when you will complete, after argument is complete, you will give it by way of a note. Yes.
Item 22.
I may be, excuse me, Lord, I am in BC, my Lord.
Yes, please.
I am in BC, my Lord. This matter.
Who's for the petitioner?
Lord, I am for the petitioner, my Lord.
Yes?
Lord, I am for the petitioner, my Lord.
Yes. Somebody is filing, you file an intervention application.
Yes, my Lord, they have filed an intervention application, but they have no locus standi to file such application because, my Lord, the very initiation of the proceeding that is.
Since this is for final disposal, please appear physically. Yes, Mr. Das, please appear physically.
I sought for some time because, my Lord, the petitioner could not come because she is suffering from brain malaria.
You want to file an objection to the IA?
My Lord, I'll file.
Learned counsel with the petitioner wants to file objection to the petition for intervention. And stop. Please this matter. 24th September, objection if any be filed in the meantime.
My Lord, refuse to receive the copy. Interim order to continue.
If he refuses on that day, you make that submission. Today he is asking for time.
2 times I have asked to receive the copy. Refuse to receive.
I say, objection can file kari.
Sir, receive for now. ଦୁଇ ଥର phone କରିଛି ଆଜ୍ଞା.
ସେ ମୁଁ ଆଉ କିଛି କରିପାରିବିନି ମୁଁ ଫୋନ କରିବି ଆଉ କଣ ମୁଁ ତ ଫୋନ କରିପାରିବିନି ଆପଣ ତ କରୁଛନ୍ତି ଆଉ କଣ ଯାହା ହବ ଆପଣ ସେ କଥା କୋର୍ଟରେ କହିବେ କୋର୍ଟରେ ଯାହା ହବ ଦେଖିବା ଆଉ କଣ ଏତେ ବ୍ୟସ୍ତ କାଇଁ ହଉଛନ୍ତି item 23
Interim order to continue.
Interim order to continue.
In this case, my lord, the petitioner is challenging the order of the sub-collector, my lord, that rejecting his for prayer, my lord. In fact, the advertisement order published in 2010. The petitioner was selected.
Selected for as what?
For environmental helper, my lord. And thereafter, without giving any appointment, or without cancelling that notification, again the CDPO passed another notification on in the year 2013. My lord. That was challenged by the petitioner before the Sonal Court, and the Sonal Court was pleased to direct the petitioner to file the appeal before the sub-collector, my lord. And that was registered as a 1 of 2019, and that was taken into consideration, but intentionally the sub-collector rejected my prayer, and for that I filed the case, and now notice has been issued. Opposite parties are giving their counter, but the copy has not served to me, my lord. And at least they may give some copy to me.
Service
I file the rejoinder.
Service
ମୋ ପାଖରେ ତ even opposite partner 5 has also taken a copy, man.
Whether the petitioner has taken
copy, no.
Let a copy of the counter affidavit filed by the state be served upon learned counsel for the petitioner.
Just now, my lord,
who may file rejoinder, if any, to the said counter, list this matter on 1st October.
Item 24.
My please. The last occasion, last was directed the State Council to comply the order dated 9/8.
The factual aspects referred to by learned counsel of the petitioner with regard to the deduction of votes in favor of the petitioner as well as private opposite party.
My lord, though I am in a position to answer it, my lord, but I want to bring it on record, my lord, by way of filing of an affidavit. Just 2 days back, my lord, the new CDPO joined and the previous CDPO got transferred. So today in the morning hour also, my lord, I had contacted.
Sriyasan Patnaik, learned AG, submits that he has received the required information, but would like to bring the same on record by way of an affidavit. He seeks some time for the purpose. Let's this matter next week. Affidavit will be filed in the meantime.
Next week, no, sir, 20.
24th. Let's this matter on 24th September. Affidavit will be filed in the meantime.
case अन्य case
Yes.
जो सुभद्रा योजना गोटे टाइम लिमिट दिखाई सब सीडीपीओ मान अंगनवाड़ी सेंटर 17 पर्यंत
So 24th,
23rd पर्यंत
24th, the interim order to continue.
Item 25.
Item 25. Null appears next week.
Item 26.
None appears next week.
Item 27.
27, Lordship, I need 3 days time to file amendment petition.
As requested by learned counsel for the petitioner, list this matter next week, as he intends to file an application for amendment. Yes. Yes.
8 Miller. I am appearing for opposite petition of 5 Miller. I am filing today the counter application.
Have you served copy?
I am solving now.
Learned counsel for the opposite party number 5 files counter affidavit after serving copy on the other side. List this matter next week.
1 week time may be granted if at all
Alright.
is required, I may file a rejoinder.
List this matter in the week commencing October first week report. No?
8th October.
On 8th October, rejoinder if any be filed in the meantime.
Now 30.
30. None appears next week.
Item 31.
1 week time cannot like a rejoinder matter.
Learned counsel for the petitioner wants some time to file rejoinder. List this matter on
4th September.
24th September. Rejoinder if any be filed in the meantime.
Item 32.
Counter has not filed.
What happened is Roger. As I said, we have already filed it through e-filing matter on 2nd of September.
It is there by district education officer though.
Yes, ma'am.
Yes, it is already there on record. Serve a
I'm
copy.
just serving a copy.
Learned counsel for the
Hard copy also, madam. Sorry.
Learned State Council files
My bad.
physical copy of the counter affidavit e-filed earlier.
Yes.
The same be kept on record. A copy thereof is also served on Sri Basu, learned counsel for the petitioner who wants to file rejoinder. List this matter 8th October. On 8th October, rejoinder will be filed in the meantime. Interim order to continue.
Item 33.
33. None appears next week.
Item 34.
In the last occasion, OP number 9 has entered appearance.
We know 9.
My lord. And I have to file the counter, my lord. But not it received, my lord.
Yes, Mr. Satpathy.
Need some time to file the counter.
Easily time at you have taken time.
First time at that
Yes. The opposite party number 9 has entered appearance through Mr. S. Satpathy who requests for some time to file counter.
I got it.
All right. Sri Satpathy, learned counsel for the opposite party number 9 seeks further time to file counter. Is this matter on?
4th September.
Right. On
1st October.
1st October. Counter affidavit if any be filed in the meantime.
35.
Yes. What is this, Mr. Ratha?
My lord, the pleadings are completed. The while working as a Hon'Ble worker, I've been disengaged by order dated 13th June 2024, which is subject matter of challenge. Now, the disengagement is made on the ground that I have produced a physical handicap certificate, which is false. This physical handicap certificate was produced in the year 2010. It was verified on numerous occasions, including the appellate authority. Appellate authority, in fact, as per the report from the CDMO has affirmed this. After all these things, the appeal has been dismissed, and then there has been a writ has been filed here, which is pending. In the meantime, a CRLMP has been filed, seeking a direction for the police to investigate. Now, on the basis of that direction, CDCID try to investigate the matter. In course of investigation, they say the certificate issuing authority say we have issued the certificate. She is a physical handicapped person having 45% disability. No such deal. They say the board has not been done on that day. The signature is not missing, not matching. All these things has been taken down. In any view, the criminal case has been initiated. On the basis of that, I have been disconnected. When the matter has attended.
You filed your counter.
Yes, in the counter they have admitted that.
Rejoinder.
No, they have not filed.
I have not filed rejoinder because they have admitted.
No, rejoinder is not necessary.
Not
So
necessary.
let us hear this. Let us hear this finally. We'll take it up after recess.
Just today, today I have a matter already on
चले
request.
शुरू करो. Learned counsel for the party submit that the matter can be disposed of finally at this stage. Is this matter on
17th September.
on 17th September?
I have argued a matter. I was directed to file a written note of
Please,
appeal.
please.
Too late. I'm sorry, Your Lordship. My lord, item number 40. My lord. Can you take up next week, my lord? Already OP counsel is there, my lord.
Item number?
43, my lord.
What is that matter?
Dear this, my lord.
When do you want?
Next week.
Next week.
Next week.
Oblige, my lord.
Because
You
the
have
matter has been amicably settled between the.
Anyway, have you filed a memo?
ନା ମୁଁ ପିଟିସନ ଫାଇଲ କରିଛି।
Call it. IE ରେ ଯୋଉଟା ହେଇଥିବ ସେ IE ରେ auditor. Yes.
Second list 38 item. I have taken consent from Mr. Hon'Ble. Let it come 1 week after.
Item 38.
38.
It's for hearing under order 41.
Yes.
ନା hearing
Oh, hearing.
hearing
କୋଉ ମସିହାର case?
এটা হচ্ছে 2003
Only next week, not.
পড়ু দেখিবে
Item 39.
ফুল মতো অপেক্ষা করব
I'm sorry, my lord. Item 39.
Yes.
And I've taken consent from my learned senior Mr. Rathod.
No, but you have not taken my consent, and that is what matters. And
I'm
I'm
sorry.
unable to give you my consent now, Mr. Manthi, so wait. Let it reach.
এটা মতো মনে রয়ে গেল নেক্সট উইক আসবে
All right, next week.
So item number 14.
In item 14, my learned friend served a copy of the rejoinder today. just now. Yes, on me it has been served. In WPC
Second.
21475.
Mr. Manti's matter.
Yes.
May I just clarify one
This is
thing?
for final disposal.
This is for final disposal. My lord, I challenge the selection of the opposite party, contesting opposite party in WPC 24171 of 2013. Appeal, selection of the opposite party was set aside. However, fresh selection process was directed, which I have challenged in my writ petition. Whereas, I think my land senior's client has challenged the very setting aside of her selection in the other case.
Both are together.
No, together, কিন্তু जो counter state the connected case, that will have a bearing on my case also.
Yes, yes.
I have not been given the copy of the counter or rejoinder. Neither of the two.
Give a copy.
Yes, yes.
Copy of the counter and the rejoinder filed by my land.
Yes, also, Lordship, kindly see, order dated 27/11/2013.
Yes.
In his case, notice has not been gone to opposite parties. I am the second case petitioner.
I'll give a copy.
You give a copy, sir. I think
I'll
you can
give a
appear.
copy.
Well, acha, how? Let copy of the counter filed by the state at a first case be served upon learned counsel for the petitioner.
At a second case, right?
No, first case.
My
Counsel for the petitioner.
To the end.
Further, let a copy of the writ application be served upon Sri A.K. Mahanti, who undertakes to appear for opposite party number.
My opposite party number 5. 5 years.
Private opposite party, opposite party number 5. You give a copy and he will give you a copy.
Clarify.
Yes.
It is your first case, your lordship was pleased to dictate the order. ସେଥିରେ ମୁଁ ରିଟ୍ କପି ଦେବି ସେକେଣ୍ଡ କେସ୍ ରେ ମତେ ସେ କାଉଣ୍ଟର ରିଜେଣ୍ଡର
ସେକେଣ୍ଡ କେସ୍
ସେମାନେ ଦେବେ କାଉଣ୍ଟର ରିଜେଣ୍ଡର କପି
ଆଚ୍ଛା ଫାର୍ଷ୍ଟ କେସ୍ ରେ ତାହେଲେ ଲେଟ୍ ଅ କପି ଅଫ ଦ ରିଟ୍ ଆପ୍ଲିକେସନ ବିସ୍ ଅଫ A.K. Mahanti who undertakes to appear for the opposite party number 5
state କର ଅଛି ନା
second case ରେ let a copy of the counter filed by the state be served upon the counsel for the other sides. Let pleadings be exchanged. Let pleadings be exchanged. That's all. Is this matter on
24th September.
24th September?
Amen.
Yes, Mr. Mahanti.
Stay ତାদের ଥିଲା କଣ?
ଦିଟା ଆଗରେ interim order
ନାଇଁ ସେଇଥିରେ ଏଥିରେ ଷ୍ଟେ ହେଇପାରେ
ଯୋଉଥିରେ ଥିଲା interim order continue କରିଦବ
ସେଇଥିରେ
yes
Item number 36.
36, my lords, this is an application for transfer of the matrimonial case. My lords, notice was repeatedly issued to the opposite party. So your lords may kind of a glance to the last order dated 37.
It was directed to be served through the court.
My lords,
What has happened?
was written by affixer, was the sub affixed on the front door, but noting is that is residing at Boragad, but Boragad address is there itself in the cost title, my lords.
Oh, someone has been served? Yes.
The wives.
Yes, yes. As directed, copy of the copy of the notice. Notice in the notice of the transfer application has been served on the opposite party Sashikanta Kumar Koro through court process as evident from the service return available in the case as evident from the service return forwarded by the court below. There is, however, no appearance from the side of the opposite party, despite service of notice. In order to grant one more opportunity to him to appear, list this matter next week. Next week, no, allow for
Item 37.
what opportunity?
My lord, in the last occasion, your lordship was pleased to issue notice by speedy post. Filing requisites.
Next week any day, date में.
Date में मंगलवार आसियो आगे.
Instead of filing requisites for post by speedy post, I have filed a registered post with
All
AD,
right, all right.
which may be accepted, madam.
Requisites filed be accepted and notice be issued as directed, fixing a short returnable date, list this matter on 8th October.
Item 38.
Item 38 and 39. Here the issue is, my lord, whenever the day is operating, the Lord and Judge Family Court, my lord, has disposed of the proceeding, civil proceeding under section 13 and civil proceeding under section 9.
She had submitted a report that applying that Asian resurfacing.
My point is now, my lord, it will be set back to its original position. So therefore, my lord asked me the judgment of that. But I have brought two judgments, and one judgment delivered by your lordship. I couldn't find it, but other two judgments I have got it.
My judgment is it's in a service matter, of course. So what will be the effect of an order passed when an interim order is in operation? So there will be restoration of status quo ante. That is what I have heard.
Here also this, or 39 2A. But it is
I refer to all the judgments of the Supreme Court also.
my lord. Here also, my lord, the judgments of Honorable Supreme Court is referred.
Yes, what do you say, Mr. Kodai?
My lord, my learned court should be challenge that order, which has been passed by the learned court below.
No, that is true, but this court had passed an order of stay. So what will be the effect? That is what I wanted both of you to examine and my judgment, you can ask Mr. Digambar Mishra. Digambar Mishra was conducting that matter. It was a forest matter, if I remember correctly. That was early in my career as a judge. Maybe in 2022, January or February.
Then I will search it. I search.
Or maybe 2021 December also.
My lord, I searched in the list of order 39 2A.
No. It's a service matter.
That was the.
It's a service matter.
I will get it. I will get
Because there was an interim order that.
That must be published, madam. I will get it. I will get it. But here, madam, 39 2A, but here it's a case of section 24 of the transfer.
Whatever. There is an order of stay.
Yes.
That you shall not proceed with the case. Now, applying the Asian resurfacing, which has subsequently been overturned. What will happen to cases during that interregnum? This is the crux of the point.
But the judgment has been passed, my lord, in this year, that 24 to 2020. That is the whole problem. If it could have been before that, then I don't have a case. But it is after revival of that earlier surface.
No. When was the judgment passed by the trial court? 4/4/2024.
Yes.
This is after the Supreme Court case judgment.
After the revival.
So without noticing that judgment,
That's it.
judgment has been.
She must have
No.
noticed.
The question is, she may have noticed the judgment, but since she has already resumed it by so-called vacation of the stay order, applying that Asian resurfacing, she decided to proceed. They deliberately continued with
I don't have any
No.
allegation against the court.
It may be a bona fide error.
Yes. That I don't have any allegation. That happens.
So what do we do?
Lordship, it must be restored to its grave.
No. For that, an order has to be passed. An order has to be passed.
It will be disabled, said to be null, as per the decision of this.
Yes, what do you say?
In that case, my order was not taken step and not filed the WS till disposal of the judgment. So the learned court below has passed this order.
That is true. That is true. But the court below itself was aware of the order of stay.
Yes, madam.
Applying Asian resurfacing, she resumed the matter, restored the matter rather. Now, when the second matter comes of the judgment of the Supreme Court, setting aside that order, the principle is that if the Supreme Court passes an order, it is deemed to be existing at all times. We have a retrospective operation always. We examine this matter, we'll take it up again next week. We'll hear it in full and pass a full-fledged judgment on that IA at least.
Yes, sir.
Third in part. Let's this matter next week. Next week, A heading the part third case. Let's see, number 2, part yes.
Number 40,
39 is the same.
13 one is also section 39, on 13 and on the 9.
Item 40. Agun ki appeal karo thile last time. None appears for the petitioner on repeated calls. We've seen that the previous occasions also there was no appearance. Hence, it is presumed that the petitioner is no longer interested to pursue the application, which is therefore dismissed for non-prosecution. Yes.
Item number 42.
But what adjourn he next week? Next week.
42, it has gone to the mediation
It failed.
and failed because he didn't turn up.
Report of the mediator indicates that the mediation proceeding ended in failure. ये तो आगु लिखा ही था उधर का दोकन नहीं ना लिखो you are the wife.
I was present along with the petitioner.
Anybody appearing for the yes notice has been served. Somebody has been appearing.
Counsel have been
Sri
appointed.
Sri P.V. Balakrishna, learned counsel for the petitioner is present. None appears for the opposite party on repeated calls. Transfer application allowed.
Item 44.
Item 44, it's infectious matter.
Dismissed as infructuous.
Item 45.
45, I am the opposite party.
Passover night. Maybe tomorrow. Yeah, Gary, tomorrow. Let's just matter tomorrow as prep. All right.
Item number 46.
The Lordship has pleased to grant vice interim bail to this petitioner for a period of 2 months and 1 month. And the matter is registered for final appeal. And the petitioner is in custody since 7 and 9, 2020. On the last occasion, your Lordship has called for the status exam. My Lord, 15 witnesses have been examined in the meanwhile. The petitioner is the driver, my Lord. My Lord, the
1629 केजी जहां देती की रिलीफ दबा के था देइचे आव हो
ड्राइवर से जे गंजेई जाठू आनिला से बेल गला
कोन करबा
जे ये
हां गंजेई जाठू आनला से तो स्पॉटर नथिबो कोन करा दियो दैट इज दी
योर लॉर्डशिप हैज granted the bail because of the confessional statement of
से कोअक्यूज्ड स्टेटमेंट रे सेटा हमनी मेंटेनेबल हो
टोटल 19 witnesses 15 हे गेलेनी सर
आया
आव हो
इंट्री बेल तक
लास्ट टाइम भी मु कहितली मिस्टर महापात्र आई रिमेंबर दिस
आउ किसी दिन
आव होबनी नाइ ना दिथर हला डे
ओनली सन तार आपण को से डेलीवरी इशू रे आपण देइथिले तो
हां तब दिया ते रिलीफ जा दबा के था देइछ आउ रिलीफ
आउ
खबर है
इंट्रीम बेल
सॉरी
आसु आगे मु 30 तारिख रे आसु मु इंट्रीम बेल पिटिशन फाइल करबे
मते पकरे कोन बे बी रिजेक्टेड पके
इंट्रीम बेल किस दिन देबे
ना इंट्रीम बेल दे सच 1600 केते केजी आगे हलानी
1633 200 grams
आ केते
आगे सी ड्राइवर तार कोन अतरे
हां सी कोन करा जियो दैट इज दी माने सॉरी स्टेट ऑफ अफेयर्स इन आवर कंट्री कित कुछ करियो किछ करियो
देखे चलो
यू वांट एन एडजर्नमेंट आई कैन ग्रांट यू एडजर्नमेंट
नहीं इंट्रीम बेल टा मुडे पिटिशन देबी इंट्रीम बेल पाई
दियो तो आपन मना कुछ आपन दियो ऑलराइट लेट्स दिस मैटर ऑन केबे
30th
नहीं 1st October
1st October
yes 47
Item 47.
Time may be said. 4 months time is allowed to the court below to dispose of the case as directed. Yes.
Item 48.
Please, your lordship.
Yes.
Lords, I am there virtually.
Yes.
My lords, may kindly look at order dated 9/7/2024.
9/7/2024.
2024. My lords.
Yes.
My lords, here your lordship granted interim bail to me.
Yes.
to undergo surgery, my lords.
Yes.
And I accordingly have undergone surgery on 31/7.
Yes.
Then, my lords, I moved IA 1060 of 2024 for extension. That was taken up on 20th of August 2024.
Yes.
So your lordship directed the state to take instructions and extended the interim bail, fixing it to today, my lords.
Yes.
Now, my lords, unfortunately, that IA has been written as disposed of in that order dated 28/2024. My lords may see. At paragraph 4, your lordship directed copy of the IA to be served upon State Council to obtain instructions and to list the BLAPL on 10th September. Para 6, my lords, extended the interim order, and then it was said that IA is disposed of. So therefore, I have filed another IA today and served copies, my lords. Now, the state had been asked to take instructions. I am not
Yes, ma'am.
sure whether he has received it.
Yeah, he seems to be all right.
My lords, because of the bandage, my lords, and the
Great
fact
bandage
that he
के लिए
is not
बुड़ेगी।
yet recovered,
Mr. Panda, I make it clear 1 week. 1 week I will grant you. Let him surrender thereafter.
can it be a fortnight?
You will definitely agree that I have granted much liberty and indulgence.
Yes, I don't
Yes.
dispute that.
How
I am
could you?
only saying your lordship may grant a fortnight.
No. 1 week.
So
1
that he
week.
can surrender and then go
Sir,
to
sir, 1 week. No, not a day more. Sir, 1 week.
Can I pray for a fortnight, my lords?
Sir. No, sir. No, sir. This is, I mean, from my side, I'll tell you, this is perfect balancing between both sides. The prosecution and the defense.
That is your lordship's prerogative. I can't say anything.
I've used my prerogative to your advantage quite often, in this case, particularly. In this case.
Well, I don't dispute that, my lords. Therefore, I am saying as a
All at 10 days. 10
last
days.
chance.
All at 10 days, sir. As directed,
My
Leonard.
lords.
Yes. See, why will you file this IA? Why not I recall that particular sentence? IA is disposed of.
I'm not sure, my lords, whether it can be done. So therefore, by way of abundant caution, I filed the IA.
All right, then we'll take up this IA. IA number 1174 of 2024. The petitioner was granted interim bail by order dated 9/7/2024, which has been extended till today. Further, Leonard State Council was directed to obtain instructions as regards the medical condition of the petitioner. Accordingly, the IIC of Plantside Police Station personally visited the petitioner at his home and found that he's wearing a knee crack belt on his right leg. Stop. A copy of the discharge certificate along with a photograph of the petitioner has been enclosed to the written instructions. The same be kept on record. Sri Devashish Panda, Learned Counsel for the petitioner, submits that because of the kneecap and the bandage, the petitioner is unable to surrender. Which is
No. What I am saying, my lords, is that because of the fact that bandaging is continuing, that injury is being treated, my lords. So therefore, I had asked for
But there is no evidence that he has been treated. So without getting into all these things, I am simply granting you 10 days time. And why should we get into all those things? Because if we look at the entire instruction that he has obtained, again, unnecessary factual aspects will be appearing. There will be disputed questions. କଣ ଲେଖିଲେ?
Yes.
Surrender, and therefore 4 weeks time may be granted to him to surrender. After hearing learned counsel for the parties and on going through the written instructions obtained by the State Council, as also the grounds raised by learned counsel for the petitioner, this court feels that ends of justice would be best served if 10 days further time is allowed to the petitioner to surrender after expiry of the interim bail. So this is the main bail application. We'll keep it pending.
Lord, actually, I had come up against an order wherein the interim bail I had prayed for, but that was not considered. So your lordship can dispose of the entire thing, saying that I may move the trial court down for regular bail thereafter.
Yes. So IA is disposed of accordingly further. BLAPL order. Since the petitioner had approached this court against rejection of his prayer for interim bail by the court below, in view of the order passed today in the IA, the bail application is also disposed of, granting liberty to the petitioner to renew his prayer for regular bail, to make his prayer on regular bail before the court below, if so advised. That's all. Yes, the bail application is disposed of.
And the trial court to consider that application despite the earlier rejections.
No, but your interim bail was rejected earlier. I have given you liberty to move for regular bail also.
Without being influenced by...
It goes without saying that the trial court, while considering such application of the petitioner, shall not be influenced by his earlier order. Yes.
That's it.
Item 49.
Urgent copy.
Urgent copy be granted in course of the day.
Much.
Item 49, mail.
Yes.
I have filed an IA for interim bill.
Yes.
Last time I got similar report for MKCG hospital for treatment. I got an letter from.
Last order.
That's a report.
Petition has been referred to MKCG Medical College for treatment of the nephrology department.
So, present commission,
I have the honor to inform that as per advisor. Who has filed it? You are giving?
Yes, ma'am. I have collected one
Who
document.
is required to shift the... Take instruction on this.
My lord.
MKCG ki jayenge.
Because earlier, he says that the petitioner is physically and mentally fit. Now he obtains an order. Find out how. How diametrically opposite instructions have been issued by the superintendent.
Yes, my lord. On 8/8, the
Now,
superintendent has
my
sent a
lord,
letter.
MKCG as per instruction. So, my lord,
Let him obtain. Let him obtain.
condition.
Genuinely, ଯାହାର ଦେହ ଖରାପ ହେଇଥିବ ତା ପାଇଁ ଗୋଟେ interim bail ଦବା।
Transportation.
ଶୁଣୁନାହାନ୍ତି ଆଜ୍ଞା ଶୁଣନ୍ତୁ କିନ୍ତୁ କୋର୍ଟ ସ୍ପିକିଂ ଟିକେ ଶୁଣନ୍ତୁ ଟିକେ ଧୈର୍ଯ୍ୟ ରଖନ୍ତୁ। When the if there is a genuine case of somebody suffering from some ailment that requires surgery, as in the present case, I was not trying to grant a regular bail, but I have granted interim bail. In your case also, many cases I have granted interim bail.
Here, both the kidney admit.
But here, if he is required to be shifted to a hospital for treatment, yes, this court can consider. But if documents have been prepared to facilitate release, then this court will never consider it. So let the State Council take instruction, because this is totally contrary to what the jailer, medical officer of the jail had said earlier.
8/8 ରେ ଦେଇଥିଲେ 16/8 ର।
So ହଠାତ୍ କି 16/8 ରେ 8 ଦିନ ଭିତରେ ସେ ହେଇଗଲା ତାଙ୍କର ଦେଖିଥିଲେ। As directed, learned counsel for the petitioner produces a letter dated 16/8/2024 of the superintendent of sub-jail Gunapur.
And this letter also indicates that only a routine checkup, nothing
Yes,
else.
it, on routine check.
ସେଇଟା କୋଉଠି ଲେଖା ହେଇଛି?
As per instruction, he is at now MKCG.
Whereby the petitioner is proposed to be shifted to Circle Jail, Barampur on medical ground. Learned State Council shall take instructions in this regard. This matter on 24th September. Yes.
Item 50. As a health condition. Health and also health.
ଆଗରୁ ଆଣିଛେ ଏଇ ଚିଠିରେ ଆଣନ୍ତୁ ଜଣା ପଡିଯିବନି ସବୁ। Yes. Item 50.
Extension of time, my lord.
First time it has come. It has come for the first time.
I'm not confirmed, but
Then you be confirmed, then we will make a submission. Where is your file, sir? Where is your brief, sir? ଦେଖନ୍ତୁ କଣ ହେଇଛି order? ନା ଗୋଟେ ଫାଇଲ ଧରିଛନ୍ତି, ଅନ୍ୟ ଗୋଟେ କୋଉ ଫାଇଲ ଧରିଛନ୍ତି, ସେଟା ବି ଭଲ ଯେ କୋର୍ଟକୁ ଗଲାବେଳେ ଗୋଟେ ଯେକୌଣସି ଗୋଟେ ଫାଇଲଟେ ଧରିକି ଯିବା କଥା, ଆମେ ବି ଶିଖିଛୁ ସେଟା। ଆମେ ବି ଶିଖିଛୁ ସେଟା ଯେ କଣ ଅଛି ସେଥିରେ ଆଜ୍ଞା, ଫାର୍ଷ୍ଟ ଟାଇମ ହେଇଛି ନା କଣ ହେଇଛି କୁହନ୍ତୁ?
pass over करो instruction नहीं
କାହିଁ ପଢିନାହାନ୍ତି, କାହିଁକି ଆସିଛନ୍ତି ଆଜ୍ଞା? Why are you not anticipating what questions the court will ask you? ଫାଇଲଟା କଣ କରିବି?
rate application
ରିଟ୍ ଆପ୍ଲିକେସନରେ ଆଣ୍ଟିସିପେଟରି ବେଲ୍ କଣ ଆଜ୍ଞା ଆପଣ ପଢୁନାହାନ୍ତି, ଆସୁଛନ୍ତି ସିଧା କୋର୍ଟ। ପାସ୍ ଓଭର
ବୁଝିକି ଆସି
ଭଲକିରି ପଢିକି ଆସନ୍ତୁ। ଏ ଓକିଲାତି ଭାରି କଷ୍ଟ ମ ଆଜ୍ଞା, ଏତେ ସହଜ ନୁହେଁ, ଭାରି କଷ୍ଟ କରିବାକୁ ପଡିବ। Yes.
Milord, the petitioner is in custody since 2/10/2020. Your lordship, in the
Your lordship on 6/9/2024 I have received a file question. तेरा खाली कह दो statement.
IA file करछि.
You have taken
principal.
Your lordship may see the
Let me submit. Sir, principal accused has already been released on bail.
Yes.
Right, bail application 1481 of 2000 since 8/4/2020. And the
Where is-
present
where is that
petitioner
order?
is the driver of the vehicles, my lord.
Sir, where is that order?
My lord, that your lordship may kindly see. That order also indicated. Yes, I have quoted.
That Bantu Srinivas Rao?
Yes, the owner of the
He is the owner of the vehicle. So how do you stand on the same footing? You were present in the inside the vehicle.
Petitioner is the driver of the vehicle.
So driver was present inside the vehicle.
No role. There are
No.
Your lordship may kindly see the orders. Your lordship may kindly see the orders.
What order?
The order Bantu Srinivas has already been released on
Bantu
bail.
Srinivas order ମୋ ପାଖରେ ଅଛି, ମୁଁ
Yes,
ଦେଖୁଛି।
your lordship, thereafter the father of the petitioner, your lordship bedridden, your lord. May I kindly see, my lord, the photograph.
Have you taken instruction? इसे photo ରୁ ଜଣା ପଡିଲା।
Shop the copy, my lord.
Is of the
soft
your lordship, nothing has been given, no document has been, only what he has said. The lordship just pointing out. Further, the father of the petitioner is suffering from old age diseases. ଏତିକି ଖାଲି ଲେଖା ହେଇଛି, ଆଉ କିଛି ନାହିଁ। ଏଥିରେ କଣ instruction ହଉ ଜାଣିଲେ ସିନା କଣଟା ତାକୁ ଏଠି ଯାଇକି hospital ଦେଖିବୁ।
4 years in
କେତେ କେଜି କେତେ କେଜି
my lord,
କେତେ କେଜି
700.
700 କେଜି ଆଉ କଣ କରାଯିବ?
The driver of the mere driver of
Outside
and the
of-
vehicles
mere driver ହେଲେ
belong
କଣ?
to the and the principal accused, he has already been released.
I did not know that there was a mere driver thing. ଡ୍ରାଇଭର ଅଛନ୍ତି, ସିନିୟର ଡ୍ରାଇଭର ଅଛନ୍ତି, ହେଡ୍ ଡ୍ରାଇଭର ଅଛନ୍ତି, ସେସବୁ ମୁଁ ଜାଣିଛି ଆମ ହାଇକୋର୍ଟରେ ଅଛନ୍ତି। ମିୟର ଡ୍ରାଇଭର ଗୋଟେ କିଏ ମୁଁ କଣ ଜାଣିନଥିଲି, ଆଜି ନୂଆ ଜାଣିଲି।
Lordship has rejected this application earlier, my lord,
Yes.
considering all those aspects.
Yes. Oh, interim bail we can consider.
हाँ, से
4 ବର୍ଷ ରହିଲେ
document देना, किसी document देना। खाली से interim bail.
ठीक है, ठीक है। This is an application आई है ना for interim bail on the ground that the father of the petitioner is suffering from several old age diseases. Learned counsel for the petitioner submits that there is no other person available in the family to take care of his father. Stop. He further submits that the petitioner has been in custody for nearly 4 years. Stop. Sri Gyanalok Mahanti, learned कौन आपनकर
Senior panel counsel central.
learned senior panel counsel for the Union of India opposes the prayer for interim bail on the ground that the details of the ailment allegedly suffered by the petitioner's father have not been given. Stop. Considering these submissions, the materials on record, and the ground on which the prayer for interim bail is made, I am inclined to take a lenient view that the petitioner be released on interim bail. ଆପଣ କେତେ ମାଗିଛନ୍ତି?
3 months. As your lords,
1 month, ହେଲା?
2 months.
1 month?
2 months.
List this bail application for hearing on 22nd October. You know what to do?
Outsider trap.
I would not have considered it, but since
4 years.
no 4 years, and he's from Andhra Pradesh.
Those people used to come
Yes,
back.
my experience is that almost everybody from Andhra Pradesh who has been released, they regularly attend the court. Each day appearance कर दो भाई, each day appearance court, and shall leave the territorial jurisdiction of the court without obtaining leave.
Item 52.
List the bail application hearing on
2nd October.
22nd of October. Stop. The court below shall furnish a report whether the petitioner is appearing on the date fixed or not. Stop. Advise your client to appear so that. Yes.
Anticipatory bail, my lord. Petition implication also 20B 2C of NDPS Act, my lord.
Yes.
The earlier bail application of the brother was rejected by the Honorable Court, my lord, on the ground that the house is in the name of the mother and the brother, my lord. And the prosecution allegation in the there, my lord, 23/2023 at about 3:30 AM, the informant along with other staff proceeded to the house of Krishna Bodnaik, and they found some persons shifted some jury bags from the veranda, my lord. Thereafter, they seen the police personnel and they fled out from the spot. That time, I directed to take instruction.
You have obtained the.
Yes, there is there, my lord. Yes, not arrested from the spot. They fled away. But here there is not a co-accused statement, my lord. Here one police ASI and the informant himself, though they are the local officers, so they identify the person, my lord.
Yes.
But no co-accused statement.
Kete kg?
306 kg.
In same police station, my lord, 9 police personnel were arrested on 14/8/2024. On the ground that they have initiated some false case and selling of ganja.
हाँ जी सी तमने जेते जो false case जेते जहाँ जेते case ही सब false case ही जो से थाना रो आपने से submission करछन्ती
Otherwise recorded in the brother man for exactly rejected.
कबनी
306 kg, my lord.
306 kg is no anticipatory bail. It is open to you to move for bail in the court below. The counsel for the petitioner is apprehending arrest in connection with such and such case. It is alleged that contraband ganja weighing 300 kgs was kept in a house which belongs to the petitioner.
No, man.
No, man, Krishna Bodnaik.
That ganja which has been kept in the house of one Krishna Bodnaik.
So you are.
He is
The brother, Sundara Bodnaik.
Sundara Bodnaik.
In the house of the brother of the petitioner. Stop. This court, while considering the application of said Krishna Bodnaik in ABLAPL number 13521 of 2023, took note of the report of the RI that the house in question belongs to him, and therefore was not inclined to grant anticipatory bail to the petitioner, but granted him liberty to surrender before the court below and to move for regular bail, to be considered on its own merit. Stop. The petitioner more or less stands on the same footing. In such view of the matter, the ABLAPL is disposed of, granting liberty to the petitioner to surrender before the court below within 2 weeks and to move for bail, which shall be considered on its own merit. Yes. Madam. Yes, Mr. Mahathir. Tomorrow, yes. कौन अच्छी किसी तरह
Transformated 3 cases are pending in Qatar.
काली ना बंद ହେଇଗଲାଣି ଆଉ
Weekly list item number 1, battered matter.
Item number 1, Lordship, brief has been transferred to us. Lordship,
brief has been transferred. This is a battered matter. When was it transferred?
Lordship, B. Beura is died, so that brief has been transferred to us.
No. On the last occasion, who was arguing?
Mahapatra. He is already consent to transfer the brief.
You are the new counsel.
Lordship.
You are appearing.
My learned senior. Yes, Lordship.
All right. Give the. Hello, take. So they have to, hearing has to be taken, hearing has to be made afresh or कौन करा जाए? नहीं, आपको वकालतनामा कहीं?
Lordship, NOC is sign or consent से दे दीजिए petitioner.
अजीत चंद्र महापात्र.
Lordship.
Sri Ajit Chandra Mahapatra. Who will appear now?
Lordship, my Lord Senior R.K. Raut. Lordship.
R.K.
Raut. Ranjan Kumar Raut.
Ranjan Kumar. What is your good name?
A.K. Behra.
Sri A.K. Behra appears and submits that his senior, Sri Ranjan
Kumar Raut.
Sri Ranjan Kumar Raut has been engaged by the appellant after obtaining no objection from the previous counsel. Stop. The no objection is also available with him. He undertakes to file wakalatnama within a week. Place this matter in the week commencing 30th September.
Next week, you
Next week, time no prepare this is a part matter. Let them some time.
2 weeks, if it will be 2 weeks, 23, 23rd.
30th.
Item 2.
Item 2. Yes.
Interim order control.
Interim order control कर दो.
Lordship. Okay.
Previously, it was not completed. No.
ये कागज फागज कौन अच्छी? LCR अच्छी? LCR अच्छा? Yes, sir.
LCR state who's party. The last state, your had fixed the substantial question of law.
No, there were two substantial questions of law framed earlier by Justice Rautray.
Thereafter, your
whether the court's belief was justified in not declaring the plaintiff as an occupancy tenant lesser in respect of the suit land, in view of the fact that he was granted Amalnama Patta on 14/1 and as such he acquired the right to be recognized as a deemed tenant under the state as per section 81 of the OE Act. Yes.
The suit was filed for declaration of right interest and for permanent injunction.
Yeah.
Injunction has been granted. Both the courts will. Suit has been partly decreed. So my continuous possession has been accepted.
But title has not been.
Title has not been given. Title actually, he prayed in a misconception that he has perfected title by adversation.
There was a very interesting question. You can find it from our judicial history, volume number 1. According to Manu, title follows possession. According to Katyayana, the reverse is true. Title follows possession. Or I'm sorry, possession follows title. Very interesting question. Including constructive res judicata. We have indicated it in our book. You must have a copy, sir. Now it is available for sale in the High Court also. We are working on volume 2 very hard. But that volume 1.
I just got a copy, in fact.
Yes. Sir, you can find out those things.
2 days back, actually, I got a copy.
A very interesting question. They are gone to such lengths, and in matters of property, but one's head will bow down in respect.
Photographs of archives.
Yes.
Right.
Those things we have obtained from different sources. Volume 2 we are working now. 1803 to 1911.
Then I'll go through it. I have seen that book. Take up some other day.
Yes, sir. Yes, to कौन संपर्क है?
Possession follows title.
नहीं, sir. Sir, later मैं कॉल लेता हूँ. नहीं, you want to take time, sir? You take.
No, in fact,
No, here you claim to be the deemed tenant.
Sir,
Your entire source of title is based on that Amalnama Patta.
Throughout my case, the Hathpota was there. That was disbelieved on the ground that it has not been registered.
Amalnama Pattas were not registered. Amalnama Pattas were not required to be registered.
Not required to be registered. They have referred to that Vrindavan Sarma case. Paripravisori. ସେଠି ଗୋଟେ concept ଥିଲା, the lease is required to be registered. Sir, 117 says the TP Act is not applicable. Registration part is not applicable. It is for agriculture purpose. Therefore, it's not mandatorily required.
Sure.
That is the ground on which the High Court has been disbelieved.
Then who's opposing you? The state.
Only state.
There are other parties also. I find private opposite party respondents.
No, perhaps not.
No,
there is no other point.
2, 3, 4 ଅଛନ୍ତି. Sukumar Das, Virendra Bisoi, Pradeep Kumar Naik. They were also different defendants.
The cause list, there is no other.
Yeah, actually, when I am looking at the appeal memo.
2, 3, 4.
Sir, I'm passing it over.
2, 3, 4.
Sir, key 7. They were the defendants.
The notice is given.
There was that ex parte.
Maybe, but was notice issued in this case? Must have been. Yes.
They are defendants, respondents, respective.
देखिए notice जाइए ना.
2, 3, 4.
Issue notice to the respondents issue. Then we'll take it up on a week or pass over for the day. Anytime you are ready, sir, we'll take it up. Yes.
Item 3.
Item 3.
Item 3, you know, simply pass over my on behalf of Mr. Mishra, senior advocate. He's on legs in another court. You will also kindly pass over if he's coming in.
Okay.
Item number 4 for orders. May please.
How much?
Alert that IA number, miscase number 9 of 2016.
Ketakoli, sir?
9. 109, sorry. 109 of 2016.
Yes, sir. Recall the order dated 18/9/2024.
Yes.
Passed.
My lord, I am for the appellate. The sole respondent died in the year 2012, which was not within the knowledge of these appellants. However, the advocate for the respondent filed a memo stating literally that he is dead and filed another memo to his legal heirs, the legal representatives of the sole respondent, to impede them as parties. In the next date, that memo was placed to be not pressed by the advocate. But the order was recorded since the advocate for the appellant didn't like to substitute the legal representatives of the deceased.
The appellants do not want to substitute the ILRs of sole deceased respondent.
My lord, that is order dated.
Rather, they want the appeal to abate.
Yes, ma'am. Actually, the memo was filed by the counsel for the respondent. That was not filed by the appellant.
Anybody who's there? Who's appearing for the other side? Anybody appearing?
Mr. Mohanty is no more.
Who was appearing? Oh, Mr. Somareswar Mahathi. Somebody must be there. We can only issue notice on this miscase. We'll have to issue notice.
I have also filed.
No, there will be, sir, there will be no difficulty in withdrawing it, but without hearing the other side, that order cannot be recalled.
No, I am not on that. I have filed another 2 IAs for substitution and another for limitation. I have also filed.
Of the same respondent.
Respondent. Because
but then it all depends. When your application for recalling this order is present, let notice go on all these petitions. All these petitions.
I have also filed another memo stating that the appellant number 3B
has died.
Yes.
He needs to be substituted or his LRs are already on record?
He will be represented
By the other LRs.
right to sue survives through other appellants. And I have also filed a petition for substitution in the respect of appellant number 6 and 2.
2 and 6.
2 and 6.
Yes.
So,
You will appear for them.
yes, ma'am. So,
So let us take up one by one. First, kindly miss case number oda kuhant. Respondent ପାଇଁ ଯୋଉଟା substitution file କରିଛନ୍ତି.
that is 109.
Yes.
To
No, 109 is to recall the order.
Recalling, yes, ma'am.
109 रे तापरे गला. तापरे 110, 112 and 111.
Another 12-9.
What? So 109, 110, 111 and 112. You should notice to the proposed LRs. Fix by registered post. Fixing a short returnable date. Requisites be filed within 3 working days. Place this matter on this is last 21st October. 21st October. 20 October. Last week. Then what are the other miss cases, sir?
My lord, 973, that is IA.
Yes.
That is for setting aside abatement. And another,
Of appellant number 6.
yes, ma'am.
Here notice is required to be issued. Yes, sir. Is notice required to be issued in this case?
What's it?
Issue note 973, 974, 975. Issue notice to the proposed LRs of deceased appellant number 6. Say order kar do. Then another 3 sets.
Will also appear on behalf of
Tell our notice kono jibu.
notice kebala E3.
973. What is the delay? Delay kete? 2020 रे 4 वर्ष delay.
ଜଣା ପଡିଲା ଏଇଟା ଯୋଉ ଏଇ ଅର୍ଡରଟା ହେଇଛି just to for abatement. Thereafter it was detected. And in the 16 this case was filed.
Notice टा जाओ. Let notice go. What do you say? Notice कर दिया. आराटा रे 978, 976, 977. इतने भी notice कर दिया. है ना? तापरे memo कोटा अच्छी?
Yes. That is appellant number 2.
It is by means of memo filed on 21/8/2024.
And another is appellant number 3B.
It is stated that appellant number 1, Bhagavati Naik, died on 5/8/2014, leaving behind her daughter, appellant number 2, as her only LR, who is already on record. So as such, no substitution is required. The memo is accepted. By means of another memo filed on 21/8/2024, it is stated that appellant number 3, capital B, expired, and his LRs are already on record as appellant number 3A, 3C, and 3D. As such, no substitution is necessary. The memo is accepted. The name of appellant number 3B be deleted. List the appeal on in the week commencing 28th October. Yes, that's all. So notice है separate order separate sets अपन को दबाव पड़ो. Yes. Yes, sir. Item 3.
Item number 3. I have submitted my note of submission along with citations. Exchange କରିବାନି ତମର ନାଇଁ କି ସେଇ ଦବା ଯେତେବେଳେ তুমি ଦବ ମୁଁ ଦେଇଦେବି ଆଉ ହେଇଛି
You are satisfied that you will briefly conclude it by within half an hour.
No, not final. No half an hour is necessary.
How come?
ମୁଁ ଖାଲି ଆପଣଙ୍କୁ ଦେଖେଇଦେବି at page 37.
37 of
37, 38 note of argument.
ମତେ ଗୋଟେ
There
କପି
is
ଦେବେ
reply.
ମୁଁ ଯେହେତୁ ଆଜି ଦେଇପାରୁନି ବୋଲି ମତେ କପିଟା ଦଉନାହାନ୍ତି ନଦେଲେ କେମିତି
No, we will exchange. ମୁଁ ପଠେଇଛି
but
preparation ପାଇଁ.
when you are preparing it submitting it I have a copy I want to have a copy.
Yes.
ହେଲା ଆପଣ ଶୁଣିଦିଅନ୍ତୁ note କରିଦିଅନ୍ତୁ. Yes, Mr. Panda. Yeah, Mr. Panda is there. He will take note. Take note. He has been trained by sir, so he can understand and he can take note.
Page 37, 38.
Sir.
ମୁଁ ତାକୁ ପ୍ଲେସ୍ ବି କରିବିନି ଖାଲି ତାଙ୍କ ସେ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ କରିଥିଲେ ଯେ on the death of the original managing partner.
Yes.
ସେଇ ଉପରେ ମୋର submission ଟା ମୁଁ ଦେଇଛି.
Sir.
That's all.
Therefore.
ମୁଁ ତାଙ୍କୁ ଦେଇଦଉଛି ସେ will exchange.
Sir. Yes, sir.
That's all.
37 and 38.
37 and 30.
39 conclude ହେଇଛି.
No, you'd like to make any further submissions?
No.
All right. Hearing concluded.
କହିଦେଇଥିଲି ଯେ ମୋର କିଛି further submission.
Hearing
କାଲି
concluded.
first hour ରେ return ର argument ମତେ ଦେଇଛି.
Hearing concluded. Judgment reserved. Learned counsel, learned senior counsel, learned counsel for the appellant files written note of submissions along with memo citations. 1 week time is allowed to the
exchange.
Counsel for respondent to file his note of submissions and for exchanging the notes. Yes. Okay. Item 5.
Item number 6.
Item number 6. No withdrawal. Item 6.
Item 6, there is a noting that no wakalatnama has been filed on behalf of the
You are appearing?
legal heirs of respondent number 1. I am filing.
You are appearing? Yes.
Yes.
N.K. Sahu, advocate and associates have entered appearance for LRs of
All the legal heirs of respondent number 1.
respondent number 1.
Distinct
The
respondent.
wakalatnama be kept on record. Your name is already there?
Already there, but
For respondent 1 to 5. Yes. That's all. Wakalatnama be kept on record.
may I pray your lordship fix up a date for hearing. Everything procedural formality now over.
Date of hearing 2009 no matter. केवे को रखो? 20 October. It will come in the week commencing 20th October. 20 October. 21st October.
20 October.
मैं सही जो week रे. Not a hearing. Yes.
Item number 7. I'm the respondent.
Lordship, I am appearing for the appellant Lordship.
Yes.
I am appearing on behalf of Mr. H.K. Moon Lordship. Kindly
Yes.
pass over the matter for the day Lordship.
Pass over for the day.
No copy of substitution petition or abatement petition or limitation petition has been sought on me. Let him sort.
Lordship will serve it.
You will appear for all the.
Only one respondent.
Oh, sole respondent has died.
No, appellant died.
Oh, the appellant has died. Okay. Serve a copy.
Yes, sir, Lordship will serve it within the course of the day.
Yes. Item 8.
The IA has been filed in both the cases. One for substitution, another for.
But where is Mr. Mishra? Pass over करें. आपको करें. Pass over for the day.
I do not know below than that.
IA number 193, 194, 195 of 2021 for substitution of respondent 8. Notice has already gone.
Yes, sir. Anybody appearing? And what about the other IA? Are there 3 IAs?
Other IA is for respondent 2
Notice-
in time.
Tinta file
564.
No, 564 is in time. All right. So what happened to the notice? Nobody has appeared?
Sir, I am appearing for respondent number 14,
No, not 14. This is for
substitution.
LRs of respondent number 8A to 8C by registered post by AD. है ना? Nobody has AD received after service. Notice issued on the LRs of respondent number 8 bracket A to 8C has been served. Since there is no appearance, number oda कहले
193, 194, 195, 2000.
which is the delay one? 194. No, 195 is the delay.
195 delay.
तीनटा के according to very well. There is delay of 85 days in filing of the petition for setting aside the abatement and substitution. It is stated that the deponent of the application was residing in a remote area and therefore could not know about the death of respondent number 8. Subsequently, after coming to know of the death of respondent number 8, he contacted his lawyer and filed the application. Stop. Considering the grounds, this court is inclined to accept the same. The delay in filing of the applications for substitution and setting aside abatement is hereby controlled. The LRs mentioned in the schedule to the petition be substituted as respondent numbers 12A to 12C.
8A.
Sorry, I would have quoted the 193 upon coin.
193.
Sir, respondent number 8 की तो आपको पता है ये percent है कहीं substitution percent है कहीं
Substitution 193, 193 substitution.
अच्छा where is that schedule को माने substitute है कहीं सर where is that schedule आपको petition टा कितने 194 तो
193 substitution. 194
194 relates to sir respondent number 8 तो
8.
अब 12A 12B लिख दीजिए
12 ना connected matter है 13 connected appeal.
193 टा ठीक देखो 193 तो schedule टा ठीक देखो I think there is some confusion here. Prayer लिखिले जे schedule given below in place of deceased respondent number 8 सुदर्शन परिडा किंतु schedule ले लिखले 12A 12B 12C
से रेस्पोंडेंट 12 भी एक्सपायर करिछि ता पे भी सब्स्टिट्यूशन फाइल
ये तो अलग है
सेटा
कॉपी पेस्ट हो कौन एटा करेक्शन करंतु एटा करेक्शन आगो करंतु be substituted as respondent numbers 8A to 8C है ना consolidated cost will be filed गला तापरे आरटा कोन
आरटा फॉर respondent 2
तुरंत 12 टा सरू आगे 194 भी आप लिख दे respondent number 8 यस सेटा सेटिंग साइड अबाउटमेंट से आलो है ना ठीक है तो 12 केते
that is another IA 564.
564 नहीं 564 is respondent number 2 इधर नोटिस जाइतला
Neta in time also.
in time ଅଛି
for respondent number 2 I was appearing your lordship allow the substitution application
you undertake to appear
I have not taken instruction because today I have received the copy of the substitution application. I will take instruction and appear.
This is an application at IA 564 है ना this is an application for substitution of respondent number 2 Sudam Parida who died on 19/2/2023. It is stated that the right to sue survives as against the legal heirs of the deceased respondent. Stop. The details of the LRs have been mentioned in the schedule. Stop. The petition for substitution has been filed in time. Sri B.S. Panigrahi, Learned Counsel, originally appearing for the deceased respondent number 2, undertakes to appear for the LRs. Therefore, the petition for substitution is allowed. Respondent numbers 2A to 2C be substituted in place of the deceased respondent number 2. Necessary consolidated cost title be filed within a week. A copy called.
INR 558, 559, 560. That is respondent 12.
Respondent 12. Eight other respondent number 12. Correction করুন। Say first year লিখে দিন তো। Learned Counsel for the petitioner is permitted to correct the typographical error in the application in the schedule to the application in court. There's delay, there is notice has not been issued.
Notice will go.
Notice has to go. তারপরে 558, 559 and 560. Issue notice to the proposed LRs by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. Is this matter? 5th November. In the week commencing 5th November. 4th November. Okay. 4th November.
Another connected appeal.
The connected matter? Yes.
That is IN number 196, 197, 198, 2021.
Yes.
That is respondent 12. In this house, respondent 12.
Is it respondent number 12? No. Notice जाइए
Notice आएगा.
Notice जाइए sufficient है देखिए. That we have to see.
Same party.
हाँ नहीं same party. Sufficient. Notice issued on the LRs of the deceased respondent number 12. Was duly served, but there is no appearance. The IN number 196, 197 and 198 and This is an application for condonation of delay. See, exactly allow consolidated appeal memo will be filed. Then out in touch.
Another say
561. I think the same order will be there.
Same order.
This is the respondent number 11 lekhai.
11 thereafter another 3 IL. That is notice will go. 565 2023 is respondent 2 is in time.
565 ta respondent number 2 arata is in time allowed. 561, 562 or 563
that will notice will go.
Notice will go. Issue notice to the proposal.
The respondent 12 procedure it is same.
Yes. Same date rasibo.
Item number 10. Item 10. Here the interim order was vacated on 17/11/2021. The Lordship can see thereafter they filed an application and it was not restored, but the order was passed.
I am appearing for the appeal.
Both parties will come ready on 15th December 2021, and we are instructed that we will not take any step for eviction till 15th December. Then the interim order was not restored at any point of time. Then a submission was made on 13/1/2023 that the interim order to continue. Though it was vacated and thereafter the application was filed, it was not extended and the order was passed that we will not take step till 15th December. And the parties should come ready for hearing. Thereafter, however, an order has been passed on 13/1/2023 that the interim order shall continue. Here is a case, my lord. The eviction decree has been.
Now, why has it come for orders?
That order sheet has come for another application has been filed on IA number. The 27 of 2023.
Yes.
For extension of interim order, and we have filed an application, interim application in 2019 for payment of the house rent at the market rate.
Has the appeal been admitted?
Appeal has been admitted.
Let us hear it.
And your lordship passed the order for hearing, and they are avoiding the hearing and filing this petition.
No, let us fix a date today.
Yes.
Let us fix a date and hearing.
The lordship fix a date.
Yes, what do you say, Mr. Mahanti? And second appeal, you should appear physically. Second appeal, please appear physically.
I'm
Unless
sorry.
you are
I'm
ill.
sorry.
Unless you are ill. Let this matter. No, it is stated at the bar that the matter being otherwise ready,
Yes.
can be finally heard and disposed of. Hence, let this matter in the week commencing 4th November.
My lord.
The parties are requested to come ready for final hearing. Yes.
I'm sorry, my lord. I'm sorry. I could not be physically present.
It's all right. It's all right.
Item number 11.
Item number 11. The first notice
Steps for issue of notice.
respondent 1 and 2, my prior manner, the state is appearing. Tahsildar and collector is the
They are
respondent.
the respondent 1 and 2.
Again. No limitation petition copy order served. And with regard to death of respondent number 6 manner, I had already filed substitution petition setting aside abatement limitation. Number is there, only notice to go to the legal list.
But today you are filing or earlier?
आज ही फाइल करते नोटिस नंबर ही
Number है नहीं.
हाँ ही 1054 1055 1056
अच्छा. नहीं. First, what did you say about that respondent number 2?
respond 1 and 2 state I saw copy of limitation.
Of these applications?
These are the respondent note 6.
Achha. So limitation of the appeal. Actually. Which is miscase number?
Miscase number
266.
again.
Miscase number 266 of 2018. Let copies of the appeal memo, let adequate number of copies of the appeal memo be served upon the State Counsel who accepts notice on behalf of respondent number 1 and 2.
Respondent 6 died.
आइए 1054
1055 1057
1055
1056
and 1056. Issue notice
to the legal.
to the proposed LRs of
Respondent
deceased respondent number
6.
This is number 6 by registered post. Fixing a short returnable date. Requisites be filed within 3 working days. Is this matter on?
In the 11th November.
In the week commencing 11th November.
October.
October how many?
Item number 12. In the meantime.
He has expired. So you have to take steps. But 2 weeks time is allowed to the appellant to take steps for substitution of the deceased respondent. Yes, does this matter?
So commencing from 28th October.
All right, 28th October.
Item number 30.
Lordship, I am for the respondent number 1, appearing on behalf of my Lord Senior Mr. Yadas. Appearing on behalf of my Lord Senior Mr. Yadas. Present here.
My lord, one I is filed for exemption of the substitution of dependent number 2, my lord. Here, my lord, the respondent number 2 has.
Why they are already on record or what?
My lord.
The LRs are already on record.
Yes, my lord. The dependent number 1 is the contesting party. Dependent number
Who died? Who died?
Dependent number 2, respondent number 2 died.
Respondent number 2 died.
2, my lord.
So you want this
again. Petition again. On that basis, this application has been filed. Though the copy has not been served upon me. The copy has not been served.
I'm serving.
But second, your lordship can see your lordship's order dated
4/9/2024. What about the order dated 4/9/2019? 4/9/2019.
That was the order 4/9/2019.
4/9/2019, this Honorable Court appointed them as receiver. And they were directed to submit the account every year. Your Lordship, this is the order.
Yes, yes, I've seen it.
Yes, madam.
On the last occasion, I passed an order.
Annual return in the month of April every year.
On the last occasion, I have passed an order that the
Your
appellant
Lordship passed the order whether this order has been meticulously
shall
complied with. or not.
satisfy the court that he has complied with the order passed by this court on 4/9/2019 in letter
Yes.
and spirit.
Now they have filed an application showing the income tax return of the 4 years. How it is relevant, the income tax return, because the property you are in possession, you are earning more than 1 lakh rupees per year. You have to file the return.
Before that, the word letter, LATER, occurring in paragraph 5 of order dated 13/8/2024, be corrected as letter, LETTR. Yes. So, where is your, you have to satisfy the court that you are.
I'll satisfy, I've got the copies, but then I will not file it, I'll file it, your lordship. Now, primary question, my lord, the plaintiff has died in the meantime. So there was a mistake, as you say, he says, my lord, I had to seek permission from the court and file fresh applications to the LRs. Copy I will serve on him. So let me take out notice on 7/22, 7/21 and 7/20. So thereafter, my lord, I will reconcile everything.
No, this court has to be satisfied that this order, previous order has been complied with. You have to file an affidavit.
I have filed an application, my lord, for acceptance of income tax returns.
So how does that?
I'll file that, your lordship. I'll find that. I've got the details now with me, all the chartered accountant certificates and everything.
This court appointed you as the receiver.
Yes, my lord.
In respect of the
The
property.
petrol.
So there is an allegation that the order has not been complied with.
Yes.
For whatever worth.
Yes, ma'am.
So you have to satisfy the court. This is a judicial order. Before that, before proceeding any further, I want to be satisfied that this court's order has been complied with.
I'm filing an affidavit.
File an affidavit. Tab likhuntu. SK Sadongi level senior counsel appearing for the appellant.
Appellant, my lord.
Undertakes to file an affidavit pursuant to order dated 13/8/2024 regarding compliance of the previous order passed on 4/9/2019. Is this matter next week?
Out to care.
When it comes to compliance of the order of this court,
No, that is, I know, my lord.
judicial order has to be complied with.
10 days.
No. ନାଇଁ ନା 15 ଦିନ ଫାଇଲ ନାଇଁ
କଳାହାଣ୍ଡିରୁ ଆସିବ ଲୋକଟେ
ଆସିବ କିଛି ଅସୁବିଧା ନାହିଁ କଳାହାଣ୍ଡିରୁ ମାନେ ଗୋଟେ 6-7 ଘଣ୍ଟାରେ ଆସି ପହଞ୍ଚିବ କିଛି ହବ
ଆଜି ହେଲା ସାର୍ ମଙ୍ଗଳବାର ଗୁରୁବାର କି ଶୁକ୍ରବାରକୁ ଆସୁ ନେକ୍ସଟ
it will be in the weekly list. You file your affidavit, it will be the entire week.
Oh, that is good enough.
Yes.
Item 15. What I was submitting, my lord, if I could take out notice to the LRs.
No, I have to be satisfied. I am very clear on that. When it's a question of allegation regarding violation of this court's order, then everything comes to a standstill, Mr. Sadongi.
No further argument on that. I'll comply.
Everything comes to a standstill, and you also being an officer of this court.
I'm doing with court, my lord. No chance. I'll do that.
Let them serve the copy of that.
You can let them, sir. I am not taking cognizance of those petitions now. I make it very clear. I will be satisfied that the order has been complied with, then I will proceed.
It's not complied with. Myself.
Item 15.
Item 15. I'm filing the application for setting aside abatement and the consolidated cost schedule.
Well, total list is limitation, that is misconceived. I am filing an objection there too. Limitation is misconceived.
Delay nahi.
Abatement by delay, but not thereafter.
କୋଉଥି ପାଇଁ ସେମାନେ ଆପଣ କେତେଟା ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି?
ଆଜି ଗୋଟେ ସିଏ ଆଜି ସବଷ୍ଟିଟ୍ୟୁସନ ଆଗରୁ ସବଷ୍ଟିଟ୍ୟୁସନ ଟା ଦେଇଛନ୍ତି, ଲିମିଟେସନ ପିଟିସନ ଦେଇଛନ୍ତି, abatement ଟା ଦେଇ ନଥିଲେ,
ସେଟିଂ ଆସାଇଡ୍ abatement ଟା
ଦେଇନାହାନ୍ତି, ଆଜି ସେଟା ଦଉଛନ୍ତି। 59 days delay ବୋଲି ଲେଖିଛନ୍ତି ଲିମିଟେସନ ରେ, abatement ରେ କିଛି ଲେଖି ନାହାନ୍ତି। ତେଣୁ limitation is there is no limitation, so it is misconceived.
Why there is no limitation?
ଆଜ୍ଞା ଫାଷ୍ଟ ହେଲା 90 ଦିନ, no limitation.
নবে দিন ফাইল করছেন সে
আগে নাই নাই 60 দিনটা হচ্ছে এবেটমেন্ট পাই
হ্যাঁ
60 দিন পরে যে লিমিটেশন আসবে
আচ্ছা
সো 150 টোটাল 150 টপিক হলে 3টা পিটিশন 150 দিন ভিতরে হলে 2টা 90 ভিতরে হলে গোটায়
So সেটা you have not submitted that. You did not bring it to the notice of this court on the last occasion.
An abatement, your lordship had asked me to file.
Abatement, normally since there was a delay, I said that you have not filed your, I have not gone through this. If this is not necessary, you take it back. You take it.
সে তো ফাইল করছেন রেজিস্ট্রেশন যেটা কিনা বেকি না
नहीं register file करना था.
না এবেটমেন্টটা ফাইল করনাহাନ୍ତି আজি ফাইল করছেন এবেটমেন্টটা
এটা consolidated file করছেন কিন্তু allow হইনি না.
It with regards to taking the leave of this court to allow the legal heir of appellant number 3 to participate in this second appeal.
No, देखिए. So this is your objection.
Yes. এপিডিবিটা মোর অবজেকশন এটা পাই নথিলে তুমি অবজেকশনটা করি আনছিলে ওগো
আচ্ছা
এবেটমেন্টটা পাই নথিলে বর্তমান পাইলি
you
নম্বর
will be,
দেইনি
no you will be appearing for all the LRs of the deceased.
No. Only I am appearing for the respondent number 1, the plaintiff in the court.
So then notice has to
Sorry, defendant number 1.
the notice will go.
Lordship, I have instructions to appear on behalf of the LRs also.
You have instructions. Then all it. Then all it.
Okay.
Right. So we'll take it on record for whatever it is worth. We'll take it on record. An application. Wrong number in here. This is an application for setting aside abatement of
Appellant number 1.
the appeal in respect of appellant number 1, Monni Charan Swai, who is said to have died on 21/6/2020. The applications, this application be registered. The applications for substitution and condonation of delay are already on record. Being IA number kete ko?
I number 455 of 2020 and 456 of 2020.
Your good name?
S. Das.
Ms. S. Das undertakes to appear for the deceased respondent appellant number
1. Legal heirs of
for
appellant.
the legal heirs of
They
the
have filed the affidavit, probably they have filed the vakalat. Your lordship may kindly the affidavit to the limitation petition.
कौन है चित्र?
Appellant, I am I am the legal heir of appellant number 1 in the aforesaid second appeal. So it presupposes they have filed the vakalat nama.
Your file. So we'll set it aside. Then we'll regularize it. We'll regularize it.
ଆଜ୍ଞା ମୁଁ ସେଇ କଥା କହୁଛି ଏଫଆଇଆର କଣ କରିବେ ଆଉ
ସେଟା already
ଆଜ୍ଞା
these
ଆଜ୍ଞା ଏଲାଉ ବାଜି ସବଷ୍ଟିଟ୍ୟୁସନ ଏଲାଉ ହେଇଛି ମୋର କିଛି କହିବାର ନାହିଁ
Yes, yes.
ଖାଲି ଲିମିଟେସନ ଟା ଇଗ୍ନୋର ହେଇଯିବ ନାହିଁ କାହିଁକି ଆଉ ଥରେ ଆସିବ ହେଇଯିବ
since the application for substitution was filed within the period of limitation, that is 60 days, there is no necessity, there is no delay, and therefore there is no necessity of filing the application for condonation of delay, which is disposed of as such.
Okay.
The application for substitution of deceased appellant number 1 is allowed.
abatement ଟା satisfied କରିବା
ସେ ଅର୍ଡରଟା ହବ ମୁଁ ଖାଲି ଯେତିକି ଦେଖିବା କଥା ରାଖି
ଆଗ ସେଟା ତାପରେ ଏଟା ଲାଷ୍ଟ
ଦେଖାଅ
ଆଜ୍ଞା
ସବୁ କଥା କରିବୁ
ଆଜ୍ଞା
ସେଟା ଆଜ୍ଞା ସବଜଜ ଯଦି ହେଇଥାନ୍ତି ମୋର ସେଗୁଡା ସବୁ ପଟପଟ ବାହାରୁଥାନ୍ତା ପାଟିରେ
ନା ସେଟା ହେଇଥିଲେ କରିଦବ
ଆମେ ବି ସେୟା କରୁନୁ କି ଅଲମୋଷ୍ଟ ବିକଜ ୟୁ ସି ଦେନ ଫର୍ମା ଅଛି ଫର୍ମାରେ ପକେଇକି ସେ କରିଦେବେ
ଆଜ୍ଞା
the appeal in abatement of the appeal is hereby set aside. Application for substitution is allowed. Consolidated copy of the appeal memo will be filed. Be filed within a week. List this matter. It has not been admitted.
No, it has not been admitted. It requires to be admitted.
I will let it be listed for admission.
Yes.
List this matter for admission in the week commencing
1st October.
21st October. ଏସିଟା ଦିଅ ଗରମ ହଉଛି ଏସିଟା ଚାଲିଛି ଏସି ଗରମ ହଉଛି yes item 16
item 16 on behalf of Manaskan I prefer pass over for the day
Item number 17.
The respondent number one died. The social there in time. But what will my lord? We have the three legal heirs. We have made them as any nickname. But my brother friend is appearing in his.
You correct the file corrected.
I have permitted to make alias. The substantial time may be allowed, so at the time of filing the consultant was right.
All right.
I will file it.
IA number kete 339 241. 339 IA 339 of 2019. Either correction कर दूँ तो अपन.
Yeah.
Either कर दूँ.
Okay.
Learned counsel for the appellant is permitted to correct the names of the PLRs of
Respondent one.
deceased respondent number 1 in court. अपने 80 court कर दूँ. This is an application for substitution of respondent number 1 Shankar Naik, who is said to have died on 13th March 2019. It is submitted that the right to sue survives on his legal heirs. The application for substitution is in time. Considering the above, the application is allowed. The LRs of the deceased respondent be impleted as be substituted as respondent number कितने हैं 1A 1C नहीं 1D again D जो 4 जन अछंती नहीं 1A B C and D. Look at page 2 of your application.
Noting shows that respondent number 1 A, B, and C entered appearance to their counsels.
4 ଅଛନ୍ତି ହେଲା ସେଇଟା ପରେ ଲେଖା ହବ. Here is allowed. Respondent numbers 1 A, B, C have already entered appearance.
So file is somehow misplaced. We are appearing for the respondent number 1, but we are not sure that whether we are appearing for the respondent 1. Yeah.
Yes.
1D पे किया फिर कुछ.
So file is somehow misplaced.
So we'll say that you are appearing.
One.
The LRs are already represented by counsel. Yeah. Consolidated appeal memo will be filed. Constitutional of the appeal memo will be filed within a week.
Right.
Yeah. That's all.
Admission
Release this matter in the week commencing 21st October for admission.
Second the same. Ali biscuit अलगा जोड़े same. Analog to second appeal.
Item 18.
आया. एक order होगा से
Respondent number 1.
इधर समान है. Analog से मेरा जोड़ा जाएगा.
Same करो. Yes.
Item 19.
Noting
आपण इसे छाड़ दियो आपण से पडू पळे आसो. Yes.
My lord, it's appeal against confirming judgment. It was admitted on 16/4/2021.
But notice could not be issued due to perform
Actually, at that point of time, my lord, the Honorable Court had directed to issue notice to court process. I had filed to court process. See the proposal noting the postal requisite by the candidate.
both ways ही तो देखिए.
नहीं से वाला order
खाली लिखा ला fresh steps for issuance of notice लिखा है तो सही में.
हमें court process से दे दिलो सीता पर पहले ना कोई postal requisite.
But what happened? The court
The
process.
former respondent is the husband of this appellant. He is no longer interested to pursue matter. We had allegation against only the respondent number 1.
Appeal notice could not.
And my learned friend is appearing for
Lordship, I
respondent.
am appearing for the respondent number 1, my lord. Lordship, I direct my learned senior to serve.
That I will do. But what about respondent number 2?
I'll take press notice now.
Press notice now.
My learned friend is appearing.
You are appearing.
They have talked to me over phone.
You have instructions to appear.
I have not filed my opinion.
All right. Your good name, sir?
Soumya Ranjan Pati.
Shri Soumya Ranjan Pati undertakes to appear for respondent number 2 by filing wakalatnama within a week.
Right.
Let copies of the appeal memo be served upon counsel appearing for respondent number 1 and 2.
One I already saw.
Sir.
Achha,
No,
one.
because-
Only IA.
IA is for
My lord, here what had happened during the pendency of the second appeal, they had proceeded with the final decree.
we'll take you up for admission today then. It has not been admitted.
Admitted.
It has been admitted.
Yes.
No interim order was passed.
None. That was due to COVID period, it was no interim order was there. So they proceeded with the final decree. I filed ex parte order was passed in final decree.
Okay.
Challenging that final decree, she preferred a CMA. That was a dismiss. Again, she preferred FAO. That was also dismissed.
So what now? What order can be passed?
I've given not to give an effect to the final decree till disposal of the second appeal.
All right. It is submitted that IA 868. It is submitted that the final decree in TS number 20 of 1999 has already been passed. Stop. Since the appeal is the present appeal is otherwise ready for final hearing, it would prejudice the appellant if the final decree is given effect to. Under such circumstances, the IA is allowed. It is directed that the final decree passed in such and such case shall not be given effect to till the next date.
Right.
कितना चाहिए? Please this matter for hearing
18th November.
okay?
18th November.
In the week commencing 18th November.
Right. Okay.
Item 20.
Item 20, I am the respondent, I am in VC, my lord. Petition filed by them for exemption.
Lordship, kindly grant some time for removing the defects.
No, my lord, that is exemption of court fee seven ଦେଇଛନ୍ତି ଗୋଟେ ଯୋଉଠି କି ସେମାନେ court fee ଆଜ୍ଞା exempted ହେଇନି first appeal in the year 2017 ରେ
On what ground?
exemption से ସାଙ୍ଗେ ସାଙ୍ଗେ ଆଜ୍ଞା ସେ poor ହେଇଗଲେ
ଟିକେ ରୁହନ୍ତୁ ଆଜ୍ଞା କଣ କୋଉ ground?
Income is lower than the 50,000.
Income
I will remove.
ତାଙ୍କର income କମି ଯାଇଥିବ ସେତେବେଳେ income
22 ମସିହାରେ ଆଜ୍ଞା
ବର୍ତ୍ତମାନ କମି ଯାଇଥିବ
ଆଜ୍ଞା 22 ମସିହାରେ ସେକେଣ୍ଡ appeal ଫାଇଲ ହେଇଛି 24 ମସିହାରେ ଆଜ୍ଞା ସେ କରିଛନ୍ତି exemption of court fee ସେତେବେଳେ ଆଜ୍ଞା court fee ସେ ଦେଇନାହାନ୍ତି ସେଇ ground ରେ ତ ଆଜ୍ଞା
probably you have a weak case on merits. That is why you are arguing your technicalities.
ନାଇଁ ନାଇଁ ଆଜ୍ଞା merit ରେ ଆଜ୍ଞା ଅଛି case ଅଛି ବୋଲିକା ମୁଁ ଚାହୁଁଛି
ତାହେଲେ ଆପଣ merit ରେ argue କରୁନାହାନ୍ତି ଦେଖିଆ
ଆଜ୍ଞା
ଦେଖିଆ
ହଁ
when do you want? What do you want?
For removing the defect.
What is the defect?
That is the.
You court fee. You file an IA ଆଉ defect to remove କଣ କରିବେ? IA will be heard.
Press କରିଦେବେ, I will file that.
Court fees ଦେଇଦେବେ ବଢିଆ IA not pressed. Then counsel for the appellant undertakes to file court fees within a week. Is this matter?
That the window will commence in 30th September.
30th September. Yes.
Actually, second case no notice was issued. 18 days.
ତାହେଲେ ଦେଖିକି ଆମେ notice କରିଦବା
Notice କରିଦେବା ସବସିଡି ଆଲା ହବନି ତେ notice ଟା ଯିବ ନା
ଫାର୍ଷ୍ଟ କେସରେ କିନ୍ତୁ
ଫାର୍ଷ୍ଟ ରେ ଆପିୟର କରିବେ
ଯାହା ହେଇଛି ସେକେଣ୍ଡ କେସରେ ତାହେଲେ
notice ଟା କରିବାକୁ
ଭଲ
ପଡିବ
yes
ଏଟା କୁ ନାଟା କରେକ୍ଟ କରି ସେଟା ଖାଲିଟା କରିବେ
yes yes after second case notice କରିଦବା ତାଙ୍କର item କେତେ ସେଟା 18 yes
Item 21. 21 defect may be ignored.
What is the defect?
Defect was that Wakalatnama was not properly stamped, but it is an appeal given to me by the legal aid, and the person who has taken legal aid, they are not supposed to pay any court fee, and we are also doing that.
That is true.
So that may be ignored and notice be issued on limitation ground.
Since the appellant has been granted legal aid, the defects are ignored. IA notice ଯିବ
Unlimited notice.
IA 8 of 2023 issue notice to the respondents by registered post with AD. No, by both ways.
Court process.
Through court process.
Only legal aid
Requisites for which But requisites से form तो अपना देबे ना. Requisites shall be filed within a week. Notice be made returnable within 4 weeks. Requisites be filed within a week तो कहले. Release this matter.
18th November.
In the week commencing 18th November.
Both sides, both were given.
नहीं.
Both were. Okay.
Court process दे. नहीं, normally both ways देता था, but এটা legal admin. 22.
T2, my lord, the noting that AD in respect of respondent number 3, 4, and 6 has not returned. That is the learned senior must have appeared for other respondents.
Milords, I have appeared for other respondents, but I'm so sorry, Milords. I'm on 23, Milords. I'm so sorry.
Yes, so you are appearing for all the respondents.
Right.
जनक भाई कौन करिवे तले ये नोटिस केबे जाइथिला
Notice, my lord, that
2023 रे so the postal tracking report will not be available. You take notice. Take fresh notice.
Notice for 3, 4, and 6.
Issue notice afresh on respondent numbers
3, 4, and 6.
3, 4, and 6 by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. Is this matter in the week commencing
11th November.
11th November.
The interim order was there.
Interim order to continue.
Item 23.
In this case, there is a delay of only 5 days, my lord.
Notice
was issued.
Notice
My
was issued.
husband has already appeared.
Who has appeared?
Mr. Dibedi has appeared. Siddhanta Dibedi.
Yes, anybody who is appearing?
My lords, I am appearing on behalf of the opposite party, my lords.
Yes.
Yes, my lords.
Only
My lords,
5
I have no objection regarding the condemnation of delay, my lords.
This is an application IA 598 of 2024. This is an application. आपको it's one question. IA 598 of 2024. This is an application for condonation of delay of 5 days in filing the appeal. The reason for the delay has been explained in the application. So further, the counsel appearing for the respondents has no objection to the delay being condoned. In such view of the matter, the delay is condoned.
My lord, a copy of the application may be served upon.
ଆଉ କଣ କପି ହବ ଆପଣ ତ ନୋଟିସରେ appear କରିଛନ୍ତି ଆଉ କଣ କପି କଣ
Notice
Aye, sir. Aye, sir.
ନୋଟିସ appeal
Okay.
all
Okay. Yes, ma'am.
Why don't you please this matter for admission on
Then we commencing 11th November.
in the week commencing 11th November. Yes.
My lords, obliged, my lord.
24, I am the applicant.
Delay.
3 days delay.
Notice ଯିବ
Notice urgent ଆଇଲି ପିଟିସନ ଯେ ଏକ୍ଜିକ୍ୟୁସନ ଟା ମୁଁ ଘରଟା ଭାଙ୍ଗିଦେବି
ତାହେଲେ କଣ କରାଯିବ ସ୍ପେଶାଲ ମେସେଞ୍ଜର ନେବେ ନୋଟିସ ସ୍ପେଶାଲ ମେସେଞ୍ଜର ନେବେ ନା ନାଇଁ ବହୁତ ଲୋକ
ସେ ନୋଟିସ ଯାଉ ମୋର ଆପଣ ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡର କିଛି ହବ
କେମିତି ଇଣ୍ଟ୍ରିମ୍ ଅର୍ଡରଟା ଦେବି ଡିଲେଟା କଣ୍ଡୋନ ନେଇବି
ଦିନେ ନହେଲେ ବି ରୁଲ କୋର୍ଟ କ୍ୟାନ୍ ପାସ୍ ଯୋଉଠି ଫର୍ମା ପପେସରେ ହଉଛି ମିସକେସରେ ତାରି ତ ଇଞ୍ଜେକ୍ସନ ହଉଛି
ଏଇଟା ଫର୍ମା ପପରିସ୍ ନୁହେଁ
ନାଇଁ ନାଇଁ ମୁଁ ସେ କଥା କହୁନି
ଆପଣ କୋଣାର୍କ ମିଷ୍ଟର ପରିଜା ୟୁ ଆର୍ ଆନ୍ ଏକ୍ସପର୍ଟ ଇନ୍ ସିଭିଲ ଲ
ଏକ୍ସପର୍ଟ ନାହିଁ
ୟୁ ଗାଇଡ୍ ଦ କୋର୍ଟ ଆଇ ୱିଲ୍ ପାସ୍ ଦ୍ୟାଟ୍ ଅର୍ଡର
କୋର୍ଟ କଣ ହାଇକୋର୍ଟ ମୁଁ କହିପାରିବି
ଆଉ କାହାକୁ କହିବି ଆପଣ
ହାଇକୋର୍ଟ କହିପାରିବି କଣ ପ୍ରୋଭିଜନ ଦରକାର ନାହିଁ ତାହେଲେ ମିସକେସରେ ହେଇପାରୁଛି ଆପଣ ଯଦି କହିବେ ସେ ଘରଟା ଭାଙ୍ଗିଯିବ ଏତିକି 10 କୋଟିରେ ଚାଲିଯାଉଛି ମୋ କାଠ ଗୁହାଳ ଘର ସବୁ ଏତିକି ହଉଛି କଥା
have you filed any where is the miscase
ହଁ ମିସକେସ୍ କରିଛି ଷ୍ଟେ ପିଟିସନ ଷ୍ଟେ ପାଇଁ କରିଛି ଇଏ ମିସକେସ୍ ହଉଛି
865 ଟା ହେଲା ଲିମିଟେସନ
ଆଜ୍ଞା ଏଇଠି ଖାଲି ଇଏ ରହୁ ତାପରେ ଲିମିଟ ଆମେ ନବୁ ଇଏ ଘରଟା ଭାଙ୍ଗିଦେଲେ ଆଉ
କୋଉଠି ଆପଣ ଲେଖିଛନ୍ତି ଘରଟା ଭାଙ୍ଗିବା ହଉଛି
ଆପଣ ଦେଖିବା ଜଜମେଣ୍ଟରେ ଅଛି
नहीं नहीं आपण এই যে মিসকেসটা ফাইল করছেন কোর্ট লিখছেন যে আপনার ঘরটা ভঙ্গা হচ্ছে তো আমাকে স্টে দিয়া যাবে
ground
কোর্ট লিখছেন গ্রাউন্ড আগে
my lord
ଆପଣ appeal member ନେଇଥିବେ ଆପଣ ମିସକେସ ଯୋଉ ଫାଇଲ କରିଛନ୍ତି ମିସକେସରେ କୋର୍ଟ ନେଇଛନ୍ତି ଖାଲି ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ଫାଇଲ ହେଇଛି ଟୁ ଟେକ୍ ପୋଜେସନ ଅଫ ଦ ଲ୍ୟାଣ୍ଡ ଆକର୍ଡିଂ ଟୁ ଦ କମିଶନର୍ସ ରିପୋର୍ଟ
ଆଜ୍ଞା ସେଠି ଜଜମେଣ୍ଟରେ ଅଛି 14 ପେଜ ସେ 1799 ମୋ ଘର ଅଛି ବୋଲି ସିଏ ରିପୋର୍ଟ ବି ଦେଇଛି କମିଶନର ଦେଇଛି 799 ପ୍ରତିବାଦୀଙ୍କ
ଘର ଭାଙ୍ଗିଦେବେ ଘର ଅଛି ସେ କଥା ସତ ଘର ଭାଙ୍ଗିଦେବେ ବୋଲି କୋର୍ଟ ଅଛି ସେ ଡେଞ୍ଜରଟା କୋର୍ଟ ଅଛି ଜାଣିଲେ ଗୋଟେ କୋର୍ଟ କ୍ୟାନ୍ ପାସ୍ ଆନ୍ ଅର୍ଡର
ମାଇ ଲର୍ଡ ଏକ୍ଜିକ୍ୟୁସନ ପ୍ରୋସିଡିଂ ଶୁକ୍ରବାର ଡେଟ୍ ଅଛି ଯଦି ଭାଙ୍ଗିଦେବେ ଆଉ କଣ
ଭାଙ୍ଗିଦେବେ କେମିତି ଭାଙ୍ଗିଦେବେ ଆପଣ ସେ କଥା ଲେଖିଲେନି ଯେ ମୋ ଘରଟା ଭାଙ୍ଗିଦେବେ there is no pleading and the court will imagine and pass an order ଆପଣଙ୍କ ଆପେଲ ମେମ୍ବର ଲିଖିଛନ୍ତି ମନା ନାହିଁ ଆପଣ ଲିଖିଛନ୍ତି କିନ୍ତୁ ଆପଣ ଏଇ ଯୋଉ ମିସକେସଟି ଫାଇଲ କରିଛନ୍ତି ଏଥିରେ ଆପଣ ସିମ୍ପଲି ପ୍ରେ କରିଛନ୍ତି ଷ୍ଟେ ଅଫ୍ ଏକ୍ଜିକ୍ୟୁସନ ପ୍ରୋସିଡିଂ
ସେଟା ପାର୍ଟ ଅଫ ଦି
ହଁ ମୁଁ ସେଟା ମନା କରୁଛି ସେଟା ମନା କରୁଛି
ଜେନ୍ୟୁଇନ୍ ଗ୍ରାଉଣ୍ଡ ମାଇ ଲର୍ଡ ୱିଲ୍ କନସିଡର ମୋର କଣ କହିବାର ଅଛି ଘରଟା ଭାଙ୍ଗିଗଲେ ଆମେ ପୋର ମ୍ୟାନ୍ ଘରଟା ଅଛି ଧାନ କଳଟା ଅଛି କୂଅଟା ଅଛି ବୋଲେ ଚାଲିଯିବ ଆଉ
No, I am willing to pass an order of status quo, maintaining whatever it is. But for that, necessary pleading should have been there.
ମୁଁ ଦେଖିଛି ଆଇ ପାର୍ଟ ରେକର୍ଡ
ସେମିତି କଣ ହବ ଆପଣ you should have when you are filing a petition ମୁଁ କଣ ଆପଣଙ୍କୁ କହିବି ଆପଣ you are so senior and so vastly experienced that I need not tell you what to be pleaded.
ମୁଁ ଦେଖିଛି ପିଟିସନ ଦେଖିଛି
ହେଲା IA 8654/2024 issue notice to the respondent by speed post fixing a short returnable date. The requisites be filed by tomorrow.
ଭାଇ ମୁଁ ଶୁକ୍ରବାର
Okay. The speed post କରୁଛି
ହଁ ଶୁକ୍ରବାର ଯିବ
ନା
ବହୁତ ଗୁଡ଼ାଏ ଲୋକ ବହୁତ ଗୁଡ଼ାଏ ଲୋକ
ବହୁତ ଗୁଡ଼ାଏ ଲୋକମାନେ କେତେ ଦେଖିବା
ମାଇ ଲର୍ଡ ୱିଲ୍ ସି
ବେଶୀ ତ ନାହାନ୍ତି 4 ଜଣ ତ
10ଟା ଖଣ୍ଡେ ଲୋକ 10ଟା 12ଟା ଲୋକ
ये सब आगुरी ହେଇଯାଇଛି ସେମାନଙ୍କର ସବୁ ସବଷ୍ଟିଟ୍ୟୁସନ ହେଇଯାଇଛି alright
ତଳ କୋଟି ଥିଲେ
because it's been filed by Friday ହେଲା IA 866 of 2024 issue notice as above accept one set of process ହେଲା status quo with regard to the suit property shall be maintained till the next date list this matter on short date karo
7th October
alright 7th October
ତାପରେ ଡିଲେ ଉପରେ ନେବି ନା ଏକାଠି ସବୁ
ଦିଟାଙ୍କ
ଫେବୃଆରୀ
last matter
Item 25. There is a delay of 45 days in preparing the appeal, my lords.
take notice
Yes. Both ways.
both ways registered postal we have nowadays that postal tracking
Yes,
facility is there
Problem.
issue notice IA 957 of 2024 issue notice to the respondent sorry one respondent by registered post requisites without fixing short returnable date requisites be filed within 4 weeks 4 weeks requisites be filed within a week
Yes.
List this matter in the
Friday,
week
also it's a Friday because execution is proceeding, so I have to.
within a week କହିଲେ ଆପଣ କାଲି ଫାଇଲ କରୁନାହାନ୍ତି କିଏ ମନା କରୁଛି ଆପଣ list this matter
18th November
ଆଉ ଟିକେ short date କର just 4 week ପରେ
28th October
28th list this matter in the week commencing 28th October yes that's all
item 50
that is one setup
one set କରିସାରିଛି ଆଜ୍ଞା ଆପଣ ଶୁଣି ନାହାନ୍ତି
ନା ମୁଁ
yes
immediately password 50 size extension of time
none appears list this matter tomorrow नहीं लिखो तू the matter was passed over on the request of counsel appearing for the petitioner however when the matter was again called out subsequently there was no appearance list this matter tomorrow yes tomorrow we'll begin the admission matters.
Pardon to mention, my lord, item number 30